Good morning. Can everyone hear me? Good morning. Hello. We're going to get started with our formal program in just a few minutes. So we ask those of you who are still standing to please get seated, and we please ask that people try to move in so that others who come later can actually get seats. In the few minutes that we have before we get started, I'd like to review a few notes with you about today's conference and this facility. I'll start by introducing myself. My name is Carly Salazar, and I'm an immigration law analyst at the Department of Homeland Security's Office of Citizenship and Immigration Services, Ombudsman. That is a mouthful, so for the rest of the day, you'll hear people referring to our office simply as the Ombudsman's office. Our office would like to start by welcoming you all here today, and we'd like to thank the National Archives for allowing us to use this magnificent and appropriate venue for our conference. I do need to mention that the Archives is a museum, and as such, it doesn't allow any food or beverage, including water, in the halls or this auditorium or the other meeting rooms that we're going to be using this afternoon. Since they are very serious about this restriction, we ask that you please cooperate by not bringing any food or water or beverage into this auditorium or the meeting spaces. You can save us from a huge fine, hopefully, if you comply. That being said, there is a cafe on this level. If you exit the auditorium corridor and head to the left, you'll see the cafe. There's also a seating area there as well. It's open today until 2:30. Restrooms, if you need to use the restroom, are located outside of the auditorium corridor towards your right, across from the registration tables. Now that we've covered these housekeeping issues, I'd like to turn to the events of our day. We're very excited to have you all, as I mentioned, joining us today. As you are aware, this is our 4th annual conference. Our theme this year is Government and Stakeholders Working Together to Improve Immigration Services. Our conference is providing an opportunity for practitioners, government officials, and other subject matter experts to interact with each other on panels and in between sessions today. So we really do hope that you enjoy your time. And each of you have received a conference folder. Inside you will notice an agenda for today's events as well as biographies for our speakers and panelists. We have a last-minute change in the sequence of events on the agenda. The Secretary of Homeland Security, Jed Johnson, has a conflict at this time, but is still hoping to join us sometime later than his scheduled time this morning. The convenient thing for all of you is that everything will be occurring in this room today. Or for this morning, rather. So I would like to start today with the U.S. Archivist, David Ferriero, who can tell you a lot more interesting information than I just did about NARA. He is confirmed as the 10th Archivist of the United States since 2009. Early in 2010, he committed the National Archives and Records Administration to the principles of open government, transparency, participation, and collaboration. He has worked on improving access and protection. He sees them as going hand in hand and has taken steps to ensure that future generations will continue to enjoy access to federal records. He's done this through directives, facility improvements, as well as research libraries. This time, I'd like to introduce to you the U.S. Archivist, David Ferriero.
Good morning, and welcome to my house. Or should I say your house, since I think this is your 4th visit to the National Archives. We're very proud to have you with us. And just a comment on the rules you heard, water is allowed here. So I can't think of a better place for you to hold your discussion today about immigration than here at the National Archives. Bringing together our nation's immigration officials and stakeholders in this historic house, which holds the records of our ancestors' immigration, makes an engaging conference even more meaningful. Our facilities create not only a very professional setting for the Ombudsman's annual conference, but also an inspiring one. John Russell Pope, who was the architect who designed this building, designed it as a temple to American history, as he called it. He believed only a monumental building in his beloved neoclassical style could appropriately showcase the most treasured documents of our democracy. He made the National Archives building taller than the neighboring structures, surrounded it with a moat, and set it at an angle to emphasize the importance of this building to the American people. He wanted everyone to know that records matter. Let me give you a little background on the National Archives. We opened our doors in 1935 with a mission to collect, protect, and preserve the records of the United States government, and most importantly, to make those records available so that the American people can hold its government accountable for its actions. We are the final destination of the most important records of the United States government, that 1 to 3% deemed by the agencies and departments to be important enough for permanent preservation here. Today, that collection translates into about 12 billion pieces of paper, 42 million photographs, miles and miles of film and video, and more than 5 billion electronic records, the fastest growing form of records now being created. We started collecting electronic mail during the Reagan administration, and between Reagan and Bush 41, we have about 2.5 million email messages, 20 million from the Clinton White House, 210 million from Bush 43, and about a month ago passed 1 billion in this White House. The records start with the oaths of allegiance signed at Valley Forge by George Washington and his troops, and go all the way up to the tweets that are being created as I am speaking at the White House. We're now in more than 40 facilities across the country, including 13 presidential libraries, from Herbert Hoover to George W. Bush, libraries which provide an invaluable record of each president's tenure and the times in which he was in office. And one of the busiest facilities is the National Personnel Records Center in St. Louis, which houses records of some 56 million veterans, as well as the records of former civilian employees. Over 1 million visitors a year come to this rotunda to see the very pen strokes from more than 200 years ago. Here at the National Archives, history comes to life. We house tangible reminders of where we have been, how far we have come, and what's possible for each and every American. Each record, large or small, is a representation of a greater story, many of which are still being told in daily life. The National Archives, I say, tells everyone's story. I'm the great-grandson, of both Italian and Irish immigrants, and shortly after I arrived, I used our passenger ship list to check the arrival of my grandfather, who we thought was the first one into the country, and discovered by using the records here at the National Archives that when he arrived at the age of 15, he was being met by his father. So it was my great-grandfather who was the first one into the country, and it was using the records here at the National Archives that I discovered that piece of my own history. Many Americans have stories like mine, and each of you probably have your own. Those stories are preserved in our vast holdings of immigration records. NARA has a strong working relationship with the Office of Citizenship and Immigration Services. The genealogy staff of the agency work closely with the History Office and Genealogy Program. CIS has trained NARA staff in the use of its records, and our staff have lectured at CIS about the 1940 census. Articles about agency records have appeared in our scholarly journal Prologue, and because of privacy issues, CIS maintains the index to some of the records in our holdings, and we refer people to the genealogy program at USCIS. These examples reflect a collaborative interagency effort. Today, as you discuss opportunities to improve the immigration process, also celebrate the ideals enshrined in the Constitution. It represents not just words written more than 2 centuries ago, but fundamental and enduring principles as relevant today as the day it was signed. I also hope you'll take some time to examine the Constitution. It's just 2 floors up in the rotunda. And if you have time, wander around and take a look at the exhibits in both the Records of Rights gallery on the level above us and in the Larry O'Brien gallery right next to the rotunda. We've got a wonderful exhibit of primary documents, about 26 in the Records of Rights exhibit, and another 26 that surround the Charters of Freedom in the rotunda. Enjoy your time with us.
Thank you again to the archivist. It's fascinating information what he shared about this building. We chose this venue for our conference because it is a collection of entry and naturalization records that makes it a really important repository for our immigration history. It just seems appropriate, so we are very honored to have this space. I have some information for you about our upcoming speakers this morning. The taxpayer advocate Nina Olson will have time for questions from the audience when she has finished her remarks. At that time, you may feel free to use the microphones that we have at the front of each aisle in the auditorium. Also, during the last session of this morning, before we recess for lunch, the Ombudsman will be holding a discussion with Leon Rodriguez, Director of USCIS. When they have finished their discussion, there will be an opportunity for the Director to take questions from the audience as well. At that time, you may feel free to use the microphones as well, or if you prefer, you may use index cards that are located in your registration folders. If you choose to use the index cards, you may pass them over to our ushers during the discussion with Director Rodriguez. If we could have our ushers raise their hands just so that everyone can see who they can flag down if they have an index card that they would like to share. So I will wrap up now and continue moving with our program by letting you know that I am personally honored to work with our next speaker on a daily basis. She has an in-depth knowledge of immigration law that she has obtained through years of practice. Since her appointment, she has led our office in identifying immigration issues and has also led the Department of Homeland Security's unified voice against human trafficking. It is with great honor and respect that I welcome to the stage our Ombudsman, Maria Odom.
Good morning. It is my honor to work with these fine folks at the Ombudsman's office. You may remember that last year we had this conference about a week after the shutdown ended, and they pulled off the conference magnificently. This year, a cruel joke was played on them. There was no email in our office, no functional email for the past 2 days. So people actually had to get up and go talk to other people and make phone calls. And it's been a very busy time, but I appreciate the resilience of our folks. They are terrific, and we couldn't do this with your efforts. So thank you, Carly. It is my honor. Welcome. Again, I'd like to echo the words of Archivist Ferrio. This is a historical building, and we are excited to be hosting our 4th annual conference. It feels that we were just here not too long ago. I always appreciate the warm welcome of the archives, and their staff just does a terrific job of supporting us with the logistics of the conference. I see in our audience prior Ombudsman Prakash Khatri, welcome. I don't see Mr. Doherty here. Sometimes he joins us throughout the day as well. Thank you for coming and for joining us for this important day. You always hear me talk about how proud I am about our democracy. I am. It is the government that was dreamed of by our forefathers and defended by so many heroes throughout our history. And these archives are filled with great details, of course. I love it because they tell us about immigrant arrivals all the way back to the early 1800s. They tell us about their lives, their nationality, their family members, even their vocation, their age, some of the things they brought with them. Recently, we started doing some work in my family, some genealogy work, so I look forward to using the archives to find out more about my folks. Our national records also hold lessons learned throughout our history, hard lessons, good lessons about our progress in building a preeminent and just immigration system, one that protects our border, but also that responds to the economic, the family, and the humanitarian needs of our nation. And those lessons are very important throughout the day. I encourage you to go upstairs and walk the halls of our archives, but also know that we're mindful that those lessons are important, particularly to those of us who have the honor of being in public service. I'm proud to serve as a Citizenship and Immigration Services Ombudsman. I love this job. I love working with all of you. I get to lead a team of people in the department charged with helping individuals and employers resolve their problems with USCIS. What a great job, right? I'm proud to be part of this team that strives to help people every day who do not experience our immigration system at its best. Our mandate calls us to make recommendations to address systemic issues in the delivery of immigration services. And while we're not part of USCIS, we work very closely with our partners there to advance our shared goals of providing world-class immigration services while protecting the integrity of our immigration services. We have worked at the Ombudsman's office through innovation to provide you with online case assistance services and to provide you with sound recommendations that are always informed by our casework, but also informed by our engagement with many of you here today. So I thank you for coming. Your feedback is key to our work, is key to how we formulate recommendations to improve our system. So thank you for taking the time to be with us. Soon you'll hear from the National Taxpayer Advocate, Ms. Nina Olson, and also from Director Rodriguez. I look forward to hearing from both of them, and also to hearing from Secretary Johnson. Our president has stolen our secretary this morning. As soon as he's done it with the White House, at the White House, hopefully he will be able to join us later today. Right now, he is scheduled to join us at noon. We are going to try to be as flexible as we can to accommodate the secretary when he is ready to join us. You know, while we focus on challenges in the immigration service, and some folks may think that the Ombudsman's office is always looking at problems and issues, that's just part of the core work that we do. I think it's fitting to kick off this annual conference by highlighting some of the successes that USCIS achieved over the past year. You know that after the June 2013 decision in United States versus Windsor, USCIS began adjudicating and approving immigration benefit applications filed on behalf of same-sex spouses. The agency effectively tracked previously filed cases and proactively reopened those that were denied solely because of the Defense of Marriage Act. And I'd like to again commend USCIS for its swift implementation of US versus Windsor. Over the past year, USCIS also issued guidance providing parole in place for spouses, children, and parents of active members of the U.S. Armed Forces. It also provided much-needed guidance pertaining to the Provisional Waiver Program. Many of you will agree is an important tool to achieving and supporting family unity. USCIS has also spent a lot of time, energy, and resources reinvigorating the Immigrant Investor Program, which is now, as you know, seeing unprecedented interest and creating probably more jobs in the U.S. than ever. So congratulations for the successful relocation of the Immigrant Investor Program to headquarters here in D.C. And USCIS granted DACA relief to approximately 680,000 individuals who were brought to the United States through no fault of their own. As you know, USCIS is now rolling out its first DACA renewal process, and we'll talk a little bit more about that later today. Before I move forward, I'd like to thank our USCIS partners in the room today. I see many familiar faces. If you could raise your hand if you're with USCIS, or unless you want to be incognito this morning, that's fine too. Thank you for all you do to work with our office. You are our true partners, and we couldn't do what we do without your engagement, without your understanding of our mission and recognition that we really do have a shared goal of providing the best service we can to the people who seek immigration benefits. So welcome, and thanks again for coming. Now, as discussed in our annual report, let's turn to some of the problems that we continue to address. Some of them are longstanding, and some of them, more importantly, provide opportunities for USCIS to improve customer service, address outstanding and new policy questions, and advance its transformation efforts. And many of those challenges will be discussed during our panels today. On the operational side, we continue to see challenges in just the overall quality and consistency in adjudications. You will read about it in our report. It spans across product lines. It does present an impediment from fully achieving the potential that this agency can when there continues to be inconsistency in adjudications. We continue to see overly burdensome and often unnecessary requests for evidence that delay processing of many cases, along with some issues of erroneous template denials and other template documents that are issued to USCIS customers. We remain concerned about misapplication or erroneous application of evidentiary standards, including the preponderance of the evidence standard, for which we've called for additional training and a concerted national effort to achieve consistency. On the policy side, we continue to press for issuance of critical guidance and new regulations, including the much-needed L1B specialized knowledge policy on the employment side, and of course, guidance to address inconsistencies across field offices in the important adjudications of special immigrant juvenile status applications, where we continue to see many problems. In the area of customer service, the agency continues to fall short of providing meaningful responses to many customer inquiries, and our office will continue to recommend that USCIS transform the way it calculates and posts processing times. As for the Ombudsman's office, it's been a big year, a busy year again. We processed more than 6,000 cases as an office of last resort with a very modest staff here in Washington, D.C. It is at 1/3 more cases than we received in the prior year, constitutes a tremendous increase in our workload. And again, our staff has risen to the occasion to address and help individuals who seek our services. This year, we expect another 10% increase in the number of requests for case assistance coming to our office. I think people continue to learn about our office. Our engagement has been robust. They know that they have an office where they can come, where they've tried everything, and we're pleased to be able to help them resolve their cases. That's at the core of our mission. Also in 2014, we published recommendations on a range of policy issues, including expanding employment authorization to certain non-immigrant derivatives, as well as recommendations to improve the quality and consistency of notices to appear. We also began issuing a number of shorter briefing papers that we share with USCIS and engaging with them a little bit differently on our policy issues. And those briefing papers have become an important and efficient way for us to conduct business with USCIS. We address ongoing problems in the processing of entry of legal representation with the agency, as well as delays in the processing of work authorization documents. We continue to prevent people from working and threaten the stability of those who do have authorization to work in this country. Finally, this past summer, we intervened in a high number of time-sensitive, delayed H-2 temporary worker cases, preventing businesses from bringing much-needed seasonal labor. There will be a panel that will discuss some of those ongoing issues. I hope you will take the time to go and learn a little bit more. Last year, we promised more engagement, more outreach, and I think we delivered. We've been busy traveling around the country, but also hosting teleconferences. We find them to be helpful, and we appreciate that you take the time to join us. We hosted 7 teleconferences in the past year and dozens of roundtable discussions in every region of the country, from Vermont to San Diego, Miami to Portland, Kansas City, St. Louis, and Chicago, and most recently, Mexico City as well. We overhauled our website. If you haven't been to our website, we would like for you to go on our website, where you can find our case acceptance criteria posted for the first time, where you can submit requests for assistance in particular cases. We're very proud of the work that's been done on our website. I'm also happy to report that we now interact with over 80,000 active stakeholders around the country, all representing different national interests and local concerns. So our list keeps growing, and we look forward to finding other creative ways to engage with all of you using our technology and using our innovation. This year, I also concluded my site visits to all the USCIS service centers. I'm very grateful to the assistance that USCIS provides as we go around the country, traveling and visiting their facilities. They do afford us, these visits, the opportunity to see how USCIS operates, to understand local practices, and discuss with field leadership and adjudicators how their work is done, but also ways that we can improve our case resolution efforts. But our engagement did not stop there. Over the past year, we've also engaged with our government partners at the Department of State, the Department of Labor, Commerce, and Justice. And I have personally, along with many of our staff, worked in collaboration with the DHS Council on Combating Violence Against Women. We will hear more about that throughout the year. It is an important council, and I'm available to tell you a little bit more about what that's about. Also, as you may know, I have the privilege of chairing, as Carly said, the DHS Blue Campaign, and that is the department's unified effort to combat human trafficking through public education and training. I see some of our Blue campaigners in the back. The Blue Campaign is a terrific effort. It is aimed at educating the community about the crime of human trafficking, but also working with state and local and tribal law enforcement to make sure that they too are trained, along with our frontline personnel, in recognizing the signs of human trafficking. Please feel free to stop outside. There is a table where you can get more information about the Blue Campaign. Later today, we will share our Out of the Shadows PSA, which has now aired across the country more than 20,000 times. We will also share some of our posters and our materials depicting different forms of human trafficking, including domestic servitude, including forced labor, and commercial sex trafficking. We're very proud of our work, and hopefully you will start seeing our campaign at major airports and also truck stops and other venues around the United States, including Amtrak trains. So what lies ahead for the Ombudsman's Office? Our work and our priorities are laid out very well in our annual report. I keep pitching it because I want you guys to take a copy and I want you to read it. I always welcome your feedback, but it lays out the issues that we have seen over the year. It lays out as well recommendations that we have made and also give you a glimpse of what our work will be over the next year as far as our policy work is concerned. We will continue to monitor the timeliness and the quality of the DACA renewal process. We remain concerned about DACA recipients, as well as we remain concerned about other individuals seeking to renew their work authorization, that be done expeditiously so individuals who have now secured employment will not lose that benefit. We will also follow new developments in customer service, as well as the implementation of any new immigration initiatives, whether they are statutory or administrative. Our office will play a role in making sure that implementation is monitored and that we remain available and open to stakeholders to bring us your comments, your feedback, and let us know what problems ensue. We will explore new innovative ways to reach and serve immigrant communities. We're currently exploring the use of mobile devices, which we know immigrants use to access the internet so that folks can submit case inquiries using their phones. And we will also continue to evaluate and hopefully deploy local ombudsmen as resources allow. That will be a first time for our office, and we're currently in the planning consideration of deploying local ombudsmen. I'm confident that with our incredibly talented staff and the reforms of the past few years, along with many investments that we have done in our office to achieve our 95% paperless office, and that focuses most of its resources in hiring individuals who are qualified to help with your inquiries, that we are well positioned to succeed. I will let Secretary Johnson know later how grateful I am, but I'll let you know how grateful I am to him for his leadership and the support of our office. And of course, I also would thank, if he were here, and I tell him every single time I get a chance, Deputy Secretary Alejandro Mayorkas for his relentless commitment to improving the delivery of immigration benefits and services. So before I close, I'd like to thank again our staff for their hard work and dedication in tackling an ambitious agenda, and finally thank all the panelists who are in this room. Some of you have traveled from out of town to be part of this conversation, and I thank you once again for joining us for this, our 4th annual conference. So thank you. Thank you. So it is a real privilege for me to introduce our next speaker, Ms. Nina Olson. Ms. Nina Olson is our national taxpayer advocate, and if you did not know she existed, I hope you walk away remembering today that we do have a national taxpayer advocate in understanding her role and understanding the role of her office. She is the voice of the taxpayer before both the IRS and the Congress. She's a renowned taxation expert, and she has spent the greater part of her career looking out for you and for me, advocating for the rights of taxpayers and for greater fairness, as well as less complexity in the tax system. So in this role, she leads the Taxpayer Advocate Service, which is an independent organization within the Internal Revenue Service, and of which our statute is based on the Taxpayer Advocate Statute, in part. And there she works with a national team of advocates charged with helping taxpayers resolve their problems with the IRS, as well as working for systemic change within the IRS and in the tax code. She's an inspiring colleague, and I appreciate her passion for this work. It's very contagious, and I thought that as much as I like to listen to Nina Olson speak, that you would appreciate hearing from her as well today. I don't think I've ever heard anyone articulate more eloquently than Lena the importance of our mission as federal ombudsmen and the investments also that must be made along with the statutory protections that need to be in place for us to be able to adequately serve the public. So why don't I stop there and let Ms. Olson tell you herself. Please join me in welcoming the National Taxpayer Advocate.
Oops. Well, it's a real thrill to be here, and I work 2 houses down, although most people don't think of the IRS building as a house of anybody's, but it is the house of the tax system, and it's actually the house of all taxpayers, even though probably no one would like to walk in there and have a visit. But actually, some of my job is to make sure that taxpayers feel comfortable with their tax authority and within their tax system, and that they have some modicum of trust of the tax agency. And in these days, that's a challenging time. I thought I would spend some time talking about the structure of my office, but also spend some time talking about how tax really relates to immigration. And just by way of my background, I started out preparing returns for families and individuals and small businesses, and some of them were very wealthy and some of them were very poor. When I became an attorney, I founded the first low-income taxpayer clinic in the United States that was not affiliated with a law or an accounting school as a clinical educational program. And that was in Richmond, Virginia, and we served all of Virginia, representing low-income taxpayers for the IRS in the states. And very early on, as those of you who work in Virginia know, in Northern Virginia, in whole parts of Virginia with migrant labor on the Eastern Shore, picking apples around Harrisonburg and Winchester, et cetera, there is a very strong, farm worker community there, very strong immigrant community throughout Virginia, and very quickly we confronted immigration issues. The United States tax system taxes U.S. citizens and U.S. residents on their worldwide income, If you happen to, by virtue of your birth or because you become a resident of the United States, under the tax laws, not under immigration laws, under the tax laws, you're considered, as defined in the Internal Revenue Code, a resident. Then you are taxed on your worldwide income unless there is a treaty that overrides our United States tax provisions. And residents, to be a U.S. resident under the Internal Revenue Code means there are 2 tests. One is what we call the green card test, even though it's no longer a green card, never mind. And that is where you all say, yes, you are a U.S. resident under the immigration laws. But the second test, which catches huge numbers of people, is the substantial presence test, which is that if you are here according to a certain formula over 3 years for a certain number of days. So, for example, in your first year here, if you're here for more than half the year, then you're a U.S. resident for the tax laws and you're taxable on your worldwide income, which comes as a shock to many, many people. And many of those people are not in compliance with the laws. And I certainly ran into that in representing low-income taxpayers, as well with my paying clients. So that's something I just wanted to throw out to you about the interaction between tax and immigration, because that's a huge issue. Just a few words about the formation of my office. My office has been around, the Office of the Taxpayer Advocate, since 1986. In the first Taxpayer Bill of Rights that Congress passed, a piece of legislation. But it was founded as an ombudsman, the taxpayer ombudsman, by the IRS in the late 70s, and Congress codified that position, recodified it, renamed it from the taxpayer ombudsman to the taxpayer advocate in 1988. And then in 1998, when there was major restructuring legislation about the IRS and as a result of very much dissatisfaction about the way the IRS was treating taxpayers, It founded my office as it stands today, renamed the position the National Taxpayer Advocate, and there are 2 code sections of the Internal Revenue Code that describe my duties. And so whenever anybody in the IRS says, why are you doing these things, I just say, look at the law. This is my job. You may not like it, but go talk to Congress up the hill. You probably won't get very far, but go ahead and try to talk to them about it, because Congress feels very strongly about how my position is designed. I've held this position since 2001. And that should tell you right there, I serve without a term. So I'm an at-will employee. I can be fired tomorrow, but, I'm still here, and I've been through 4 Treasury secretaries and 3 presidents, and I don't know how many other, commissioners of Internal Revenue Service. So that's sort of informative. I myself am appointed by the Secretary of the Treasury. By law, I report to the commissioner so that I'm inside the IRS, but the commissioner has no authority to hire or fire me. So that's a little safety valve there. By law, I am not allowed to have worked for the National Taxpayer Advocate cannot have worked for the IRS for 2 years before he or she takes the position, and for 5 years after he or she leaves the position. So that is how you really protect the independence, that you have no career path in the IRS. 0, zip, none. So I'm not looking for approval from really anybody except the taxpayers of the United States. They will certainly let me know if I've done their job, the job that they need me to do. By law, I am required to help taxpayers solve their problems with the IRS and identify the administrative and legislative causes of those problems, and then report to Congress on those administrative and legislative problems. I am authorized by law to issue 2 reports to Congress a year. The December report, which is by far the largest, 700 pages, I have to identify 20 of the most serious problems that taxpayers are experiencing with the IRS, report on the 10 most litigated issues in the courts that relate to tax, and then make administrative and legislative recommendations. And I am, in fact, the only IRS employee, not even the commissioner can do this, who can go directly to Congress with legislative recommendations without having to go through the Office of Management and Budget, the Department of Treasury, or the White House. And that happens by my issuing the reports directly to the tax writing committees of Congress, the Ways and Means and Senate Finance Committee, before any employee of the IRS, any employee of Treasury, any employee of the Office of Management and Budget see that report. And that is in the law. That is by law that I do that. And I've had some little battles with IRS officials about that, but that is my vehicle for making the legislative recommendations. Congress wanted a clear and uncensored voice about what was going on inside the IRS, and we have tried to really respect that voice. By law, I have at least one office in every single state. There is a local taxpayer advocate in at least every single state. I actually have 74 offices around the nation, including one in Puerto Rico. There are many states that have more than one, California, Texas, New York, Pennsylvania. I mean, a lot. Obviously, with 74 offices, I have more than one. I have an office in Washington, D.C. that serves the taxpayers in Washington, D.C., the federal taxpayers. I have about 1,900 employees around the United States. I have, we receive on our case side, the branch of my statute that says help taxpayers solve their problems with the IRS. On that side, I get anywhere from 220 to 300,000 cases a year annually. On the systemic side, I have a small staff, about, I'd say now 50 people, plus a research function who work on systemic issues. And we have a system in which anybody, IRS employees, taxpayers, anyone can submit what they identify as a systemic problem online, and my staff works it and tries to identify what the causes are. Is it indicative of a larger issue? Many of those submissions actually become a basis for our discussing most serious problems in the annual report to Congress, or become evidence of a problem we've already identified, but throws a little angle to it. So really going into transparency and accountability. Let me think what else I want to say about this. Okay, one of the unique things about my office, and this is the second statutory provision in the law, taxpayers come into my office when they have a significant hardship. That's a term of art defined in the law. In the law, I would say that the best way to describe it is significant hardship means because the IRS has done something, has failed to do something, or, is just basically a system is completely broken, is causing significant hardship to the taxpayer. And significant hardship can mean economic harm of some sort, and that can be for individuals or businesses. I will tell you, the first week that I got on the job, an entire country came to my office, came to me for help. No one had told me I was one of my constituents was a country, but that was okay. We worked it out with the IRS. They were having a problem with the IRS and getting an interpretation, and they came to my office to intervene. It was like, okay, that's in my job, fine, I'll do that. The other side of it is where a system is broken down. It's taking too long. You've tried to resolve the problem with the IRS. This is the traditional ombuds function. So we have the economic burden and the systemic burden. And then the third prong really is taxpayer rights. And I'll sort of close with a discussion of taxpayer rights because that is the heart and soul of my office. The IRS is such a powerful agency. It is the most powerful creditor in the United States. Its powers are so broad to be able to take property from people that it raises really due process issues, Fourth Amendment issues, and some of its penalty functions raise Eighth Amendment issues, unreasonable fines, and punishment. And these are all things that come squarely within the purview of my office, which actually makes it very interesting work. But one of the things that I have the authority to do by law is to issue what's called a taxpayer assistance order. When a taxpayer comes in for our assistance and the IRS is not doing what we think is the right thing for the IRS to do with respect to that taxpayer and they have failed to respond to us, I can order the IRS to do something, stop doing something, or not do something it's about to do. And my local taxpayer advocates are able to issue that order, but if the case comes very quickly up to me, if we are not able to get agreement through the appeal process of that order at a lower level, if it gets to my desk, then only myself, the commissioner, or the deputy commissioner can modify or rescind that order. I believe that it's right that the buck stops at the commissioner level because he is, of course, the head of the organization. Really only the commissioner the commissioner can finally overturn my order. But I actually do get the last word because the statute that orders me to report to Congress requires me to report to them every year about any taxpayer assistance order that I have issued that the commissioner has not complied with. So he can say, no, we're not doing it, but I get to tell Congress and the public that I have ordered this and the commissioner has refused to do it. And then if Congress doesn't like that, they can go and talk to the commissioner. And there have been many instances where the commissioner has gotten a letter in response to my ordering something that the IRS has refused to do. And then that has moved the ball a little bit long. So I have many tools. There is also a non-statutory provision called the Taxpayer Advocate Directive, which is delegated solely to me as the National Taxpayer Advocate, whereas the Taxpayer Assistance Order deals with individual taxpayers, and their individual cases. The Taxpayer Advocate Directive deals with systemic problems. So there may be a group of taxpayers or all taxpayers, and something the IRS is doing with respect to that group. I can order them to change their processes, not change their processes, whatever. And again, only the deputy commissioner or the commissioner can overturn me. And I, of course, always report about that. I have actually used taxpayer advocate directives in the context of immigration issues, in the context of individual taxpayer identification numbers. I am very concerned and have identified as a most serious problem of taxpayers the ITIN process for, 7 years or so. I've only been here for 4, so half of my time here for 14 years, I have been identifying that as a process that is really problematic and harms taxpayers. We still have processes where taxpayers, in order to get that number, which they are required to have, remember, because if they can't get a Social Security number, but they are still taxable on their worldwide income under the Internal Revenue Code because they are considered, U.S. residents, not by immigration policy, but by the tax law, they have to have an ITIN to do that reporting. And in order to get an ITIN, they have to produce a lot of identity documents. And unless you are lucky enough, to be near a certified acceptance agent or one of the 3 IRS tax attaché offices that we have in embassies, we just closed, or we're closing on November 30th, our 4th one in Beijing. I guess we don't care about where we are is that you actually, for your children, you will have to send their passports in or other identity documents, which I don't know. I would not be sending my passport to the government except to get a renewal, but certainly not to some entity in the bowels of Austin, Texas, to process it. And we have had cases where identity documents have been lost, and people in countries where they need to leave for very important reasons having to do with the safety and protection of their lives. We have their documents, and we have lost their documents. So I am very concerned about that, and have issued taxpayer advocate directives. This is all tied up with Homeland Security, and actually this year we're going to be doing a considerable amount of work, and I will be going down to the ITIN office in Austin, Texas in December to actually really sit down with the employees and talk about how we can improve it. That's an IRS function that really needs to be improved. I thought I would talk a little bit about how taxes really do interact with everybody's lives and immigration. Maria talked about Windsor. Windsor was a tax case, right? Windsor is actually, Windsor is an estate tax case that the same-sex spouse of the deceased person wanted to claim the marital deduction that you're allowed on an estate tax return, so that you don't have to pay any estate tax on the death if you're giving your property to your spouse. There's a marital deduction. And because the law didn't recognize that marriage, there was a large estate tax bill. And they went to court to say that is a violation of the U.S. Constitution, equal protection. And so the law that really did major damage to DOMA and that whole regime was a tax case. You've talked about domestic violence. One of my first training sessions for low-income taxpayers and in my low-income taxpayer clinic was as a result of the 1998 Act, where we got in the Internal Revenue Law expanded innocent spouse relief, where a spouse, and now same-sex spouses, but then it was, husband and wife, opposite-sex spouses. Well, I've never quite understood what opposite sex really means, so I haven't come up with a better way of saying that. But anyway, male and female. That when you sign a joint return, you are jointly and severally liable for the tax on that return. And if the IRS comes back and makes an adjustment, they're going to hold both spouses liable for that additional tax. And we have lots of cases where one spouse or the other has come in saying, I didn't know about this additional income, my spouse hid it from me. One of my first cases was in the clinic was a woman who had come here, immigrated here from Egypt with her husband, and she was definitely an abused spouse. He had had a mistress on his side and was making tons of money that he was spiriting away on his side and actually sending back to Egypt. So we can just think about all the different laws through all the different federal laws that have been violated in this act. He had been lying about the amount of money that he was making to his wife, who had a 2% English reading comprehension, and a daughter who had tuberculosis and was cutting hair at the hair cuttery, making about $10,000 a year while her husband was spiriting money out of the country. The IRS found out about this money and put a lien against their home. It was tens of thousands of dollars, and then her husband fled the country and was beyond the reach of the United States because we didn't have a policy, an agreement to bring him back in. And then here's this little wife who didn't know about the money, didn't receive any benefit of the money, and her whole financial life is destroyed. And the case came in and had been bouncing around for years and years and years and years in the IRS, and I was finally able to get somebody in the IRS to look at the case. And this is actually one of the great touching stories of my life, and I'll try to say it without choking up. But I had written this story basically to try to get somebody to pay attention to the facts of this case, not having to make anything up of this tragedy. And the agent that was finally assigned to us, met with me, and he said, when I read the file, my mother was in Poland and was in a work camp, and she escaped at 13, and she came over in steerage to the United States. And all I could think about was my mother as I coming to the United States at that age and reading this story of this taxpayer. So because of that story and that person's history, I was able to get relief for this taxpayer, $30,000 in refunds that had been grabbed from her over about 8 years. It also happened to make her ineligible for the earned income credit that year because she had so much interest income from the United States government because we'd held her money for that long that it bumped her out of eligibility for the earned income credit, which is a nice problem to have, at least for that year. But that is how you see sometimes the interaction. When you're talking about domestic violence, it's very important to think about the fact that there will probably be tax consequences. And even, from past filings, and even as you get people safe, you need to also make sure as they start their new lives that their new lives are not destroyed because of the tax liability from a past, from that abusive relationship haunting them for the rest of their lives. And that's where the innocent spouse provisions come in. And my office does a lot of work with domestic violence shelters here. And I actually look very forward to working with you all on that issue to bring a tax angle here. I did also want to talk about the low-income taxpayer clinics. That legislation is very important. It's actually in the law. And that is how I came to the attention of Congress, was in 1998 in the hearings in 97 and 98. They asked me to come up and talk about the work that I was doing with low-income taxpayers. And I talked about how the clinics actually needed funding because when you go in, it's very hard to compete with foundations for domestic violence or AIDS research or cancer research or whatever, or even hunger. Then you start talking about tax and people's eyes glaze over. They can, and by the way, how can poor people have tax problems? Well, I've just given you some examples of how they can. So Congress, the Ways and Means Committee, and the Senate Finance Committee invited me to testify during those hearings. And as a result of my testimony, Congress enacted Section 7526 of the Internal Revenue Code, which provides for a matching grant program for low-income taxpayer clinics who serve taxpayers up to 250% federal poverty level, which really is the working poor. That's what we're trying to get at. And there is a very important provision there because the clinics are required to serve both low-income taxpayers, all low-income taxpayers, but also educate taxpayers who speak English as a second language about their rights and responsibilities under law. And this law came in at the time that Congress was also looking at restricting the Legal Services Corporation grantees to not be able to represent undocumented. And I was very, very careful because of the way that residency in the United States is defined in the Internal Revenue Code. We are pulling undocumented taxpayers into the Internal Revenue Code and the tax system. We don't care what their immigration status is. They have a requirement under the law to file their income tax returns, whether they're documented or they're here undocumented. And so these clinics are able to represent undocumented taxpayers before the Internal Revenue Service, a very important service. Today, I now, ironically, administer that program, that grant program. And we have 136 clinics around the nation. I think there's only one state right now this year that we don't have one clinic in, and a clinic in. And I give out $10 million in grants a year. And I am enormously proud of the work that these clinics do. They actually undertake about 10% of the litigation, tax litigation in the United States tax court. That's how much their work is. It's really profound. And what it has done is it has brought about, and this is what really resonated with Congress, and it goes back to rights, is that, without representation, you are really not able to have your voice being heard in the tax system, a system as complex as ours. And so the case law only reflects the issues that are brought by people who are able to afford representation. And that does not lead to a fair and just tax system where a whole 40% of the U.S. taxpayer individual population is at 250% federal poverty level or below. So the tax law would not reflect the issues and concerns of 40% of our individual taxpayer population without the work of the clinics and the pro bono representation that goes on there. So it's a really profound addition to the fairness of our system. I think, to open this up for questions, I would just to close, I'm going to touch on two more issues that are really affecting us in the immigration context and individuals abroad, and then close talking about the Taxpayer Bill of Rights. There are two provisions there's a provision called FBAR that has been in the law. It's actually under FinCEN, this provision in the Department of Treasury, And it is about reporting foreign accounts, the existence of foreign accounts. And it's been in the law for a very long time, and nobody did anything to enforce it. And now the IRS has been doing a lot of enforcement. And there are huge penalties attaching to it. If you do not report on a particular form the existence of an account over $10,000 abroad, an offshore account, an account is defined very broadly. The penalties can be up to 50% of the high account balance per year over 6 years. So we have many cases where the balances actually are zero or very close to zero now because of the stock market or something like that, and the penalty itself is larger than the actual balance of the account today. And when you think about all the stories that we've seen, people who are accidental citizens, the whole country of Canada, just happening to be born here or something, or having a United States parent, never setting foot in Canada, this provision, I have lots of, pen pals now from Canada because of what's been going on there. You have seen a spike in renunciations of citizenship as a result of these provisions. People who didn't realize, they were enjoying the privileges of being a United States citizen, never realized worldwide taxation because they never really came here. It was just something that was by virtue of birth that they had it, or one parent. And they've spent their entire time overseas, and suddenly all of their accounts overseas are pulled into our reporting system, where you could be losing 300% of the balance of those accounts. That to me raises Eighth Amendment issues about the proportionality of the penalty. And we have been very active in many, many cases here. But I think that's something that I've been thinking as I was preparing, my thoughts for here, that's something that I'd like to work with Maria's office about, is getting better information out as people come into this country about the tax consequences of, things that they wouldn't really ever think about. They're keeping an account at home to help fund their family. Some of their family members may stay at home, and it's over $10,000. You're here for a certain amount of days. Sorry, you've got to file an income tax return, and you have to tell us about that account. And so there's another provision that's coming into law now that will deal with some persons abroad dealing with, foreign accounts. All of this is to combat offshore tax evasion, because we reach everybody who, has that meets that definition of being a U.S. citizen or U.S. resident under the law. But these are really complex provisions, and we're seeing a lot of people being caught up unintended. They want to comply, and they're facing really serious, penalties. And I have also been told that it is really making some people in business not want to do business in the United States, just because they're concerned that just by a footfall, they might end up having to lose a significant amount of their assets. So to close, I just want to talk about something that happened on June 10th in the United States. This document, which you may or may not be able to see, but I'm going to present it to Maria, is the Taxpayer Bill of Rights. I have recommended since 2007 that the Congress adopt a Taxpayer Bill of Rights, on the idea that feeling that the best kind of compliance with law occurs because individuals and businesses have trust that they will be treated right, that they have rights before the law, and they will be treated correctly and well if they make a mistake, and that there are remedies if they are not being treated well. And although there have been 3 pieces of legislation titled the Taxpayer Bill of Rights, these statutory protections were scattered all over the Internal Revenue Code. My office did a survey of United States taxpayers in 2012, asking them, do you believe you have rights before the IRS? This was a representative sample of U.S. taxpayers. 44% of them said they believed that they did, so more than half the taxpayers in the United States believe that they don't have rights before the IRS. We then asked them, do you know what those rights are? And only 11% of the taxpayers of the United States said they knew what their rights were. That is pitiful. So this year I recommended in my annual report that forget about waiting for Congress to enact the Taxpayer Bill of Rights, although last summer the House of Representatives on a bipartisan vote adopted my recommendation, so it's just that the Senate didn't pick up that piece of legislation. So I recommended that the IRS Commissioner adopt it, and on June 10th of this year, the Internal Revenue Service adopted the Taxpayer Bill of Rights, basically pretty much my language. And it's modeled after the Bill of Rights that resides in this building, in the idea that there are 10 rights And then we have mapped the statutory protections to each of those rights so that taxpayers can learn about those rights in a high level. I always say, taxpayers, individuals know that they have the right to free speech. That's in our blood. If you think that somebody's infringing on your speech, you say, wait, don't I have the right to free speech? Now, the answer might come back, well, actually, no, in the crowded theater here, you can't cry fire. You don't have that kind of speech. You cannot make speech to incite, the call to arms, to bear arms against this country. There are limitations on free speech. But saying, don't I have the right to free speech, starts that dialogue, and you learn what your rights and your remedies are. So if you know your 10 rights, you can say, wait, number 10, don't I have the right to a fair and just tax system? What does that mean? And what statutory rights, what enforceable remedies are under there? And in this year's annual report to Congress, we will be making legislative recommendations to plug some holes, some gaps in the remedies that are available under these rights, where there aren't some remedies under some of the rights that are promised in our Taxpayer Bill of Rights. So that's an incredibly important document. I would say that plus the low-income taxpayer clinics is my life's work, and I could just fold up my tent and go home, but I'm not about to yet. So I hope I have a few minutes for questions, and I'm more than happy to answer any concerns that anybody has or any questions about my office and the working with it.
If you have any questions, please come down and use the microphones at the front of each row. We have a question from a card. What is your greatest challenge as a taxpayer advocate?
Well, the tension in my office, I said, and Maria said, that my office is independent within the Internal Revenue Service. And so, whereas people are very comfortable or used to external watchdogs like GAO, or we have our own Inspector General of Tax Administration, the idea of having somebody inside the building present I am part of the senior leadership team of the IRS, so I am at all of their internal meetings. I know what's going on in the building, and it makes people very, very nervous. And so some of the thing is I've joked, but it's also very true, that there is not a meeting that happens once a day where somebody is saying, don't tell the taxpayer advocate about this, which is a really stupid thing to say, because within 15 minutes of the end of the meeting, somebody's calling me to say, Nina, I think you should know about this, which is the other reason why I am in the building, because that kind of conversation happens, which would be impossible to find out if you were outside the building. But it creates a certain tension. I think over the years, because I have basically outlasted about 4 senior executive teams. There's no one on the leadership of the IRS today that has been there as long as I have, that I know all the bodies that are buried in the building at this point, and that is a very powerful tool when someone's saying, I'd like to do this, and I'm going, no, you tried it in 2003 and it didn't work, and I'm not going to let you do it again. Now, I may be lying, because no one was there in 2003 to know, but it's a really powerful tool. But that tension, and I have often said to folks, look, you have 2 choices. You can either tell me this, you can work with this, you can listen to what I'm saying and work inside the building, or you can do it with me talking to Congress outside the building. And so you've got, if we're working on something inside the building and we're making progress, then I'm willing to work with you. If you are not willing to work with me, and you are ignoring my concerns, and I don't raise frivolous concerns. They're very well researched and they're very documented because of the cases that we have in-house. If you're unwilling to work with me, then you're fair game for a most serious problem for Congress. And at least twice in my lifetime here, my most serious problems have made the lead editorials in the New York Times. That's a statistic I don't often throw out, but it's also true. That gets some amazing attention. One of those editorials, the commissioner was over in China, and he was brought back by Treasury back here to deal with the issue that I had identified, which was, by the way, I felt a Fifth Amendment, due process violation. So it was an interesting issue. Somebody else had a question.
Hi, I work for the University of Virginia, and we deal a lot with foreign faculty and staff. FBAR right now is a huge topic for us because we are also struggling on how to inform our faculty about the regulations and their duties to pay under the law. So I have two quick questions. The first one is, how does FBAR differ from your general duty to report worldwide income as a foreign national? And the second one is, what suggestions do you have for organizations that want to make their foreign faculty, their foreign employees very aware of their duties and just, make the law very transparent to them?
So a couple things. FBAR is not part of the Internal Revenue Code. It's actually not a tax provision. As I said, it's under FinCEN. It's sort of an aspect of the Bank Secrecy Act. And it is focusing not so much, it has a side effect in that if you can find these accounts are often sheltering, income that should have been reported on people's United States income tax returns. And the FBAR penalty is supposed to be a tool to discovering these accounts. What there really is there are two requirements. One is the requirement on your interest schedule, Schedule B of your 1040, that says I have an account that is more than $10,000 and it's offshore. And once you have that, that triggers your FBAR filing requirement. And that form doesn't really go to, well, I think now it's going to the United States, but to the IRS, but it's actually, the regulations and everything are owned by FinCEN and the Department of Treasury. So, but the IRS, because of the income tax consequences and because we are the collection arm, is basically the owner of all the operating aspects and puts out a lot of the FAQs about FBAR. So that's where we get involved. My suggestion to you, and I'm going to give you my email address because I do this at every talk, and all I ask people is don't email me all at once. But I have experts on my staff for FBAR, and we have been working up outreach materials for people, trying to do a quote-unquote plain, simple language explanation of FBAR and FATCA requirements. And it is Nina, N-I-N-A, .e.olson, O-L-S-O-N, at irs.gov. And one thing that we've been considering, because we've gotten a lot of requests from universities, not just for their faculty, but also for foreign students, is to maybe do a webinar or something that would try to walk through, and it could be audio taped, and then you could play it, people could link onto it from our website and things like that. So I'd really welcome the opportunity to work with you. If you want to email me and just say you raised that question, I can put you in touch with my folks, and we can work up something for your university to become sort of a model that we could put on our website and others could tune into it too. It'd be very helpful for me. I'm very concerned about this. It really is, there's a lot of offshore tax evasion, and, governments, right now the United States is leading other governments. We're actually going to be sharing massive amounts of financial account information under the other provision, the FATCA, the Foreign Account Tax Compliance Act, that Congress passed. And there'll be a lot of exchange of information between governments, which is going to be really interesting to see how that plays out, because people here may end up with problems overseas because other overseas governments are getting some of the information that we have pursuant to some of these intergovernmental agreements. And that's another issue to think about as well.
There appears to be
There
appears to be a systemic problem with the IRS processing of Section 529 college savings plan distributions. I don't know if you're aware of that, and if you could speak to what's being done about that.
Well, I don't know what the problem is. So, that's new to me.
Okay, so basically, every year the college files with the IRS the expenses that are qualified, and the state plan files with the IRS the distributions. And then every year the IRS sends out a notice to the taxpayer saying, this is taxable income, and then the taxpayer calls up and says, no, it's not, there are qualified expenses and they've been filed with you. And the response has been, well, our computer system doesn't factor that in or doesn't process it or whatever. There seems to be a disconnect between those filings and the IRS system, and so then the taxpayer has to send in the same documents that have already been filed, and then they say, okay, forget about it.
So I'd say to you the same thing. That's a great issue, and I would really like you, do you need my email again, or did you write it down? Because I'd like you to really email me that. We have a system called the Systemic Advocacy Management System, which is available to the public. It's on our website, taxpayeradvocate.irs.gov. And individuals, anybody, can submit systemic issues, and then I have a staff that review them every single day. And issues like that, then we might do an information gathering assignment where we see, okay, is this just one freak occurrence, or is this really going about? And then we would create a project working with the IRS to try to get them to stop doing that. And if we can't get a fix, then it might very well become one of our most serious problems. And we have had not so much the 529s, but some of the issues about the tuition expenses and things like that in the reporting. That has been in our annual report before, and we've actually made some legislative recommendations about that. So that would be very interesting to me. The IRS does a lot by computer matching now, and so when they, and it's not, the computers are only as good as you program them. And that's a classic example of putting burden on the taxpayer, where we should just be able to fix it like that. And if it means putting another box on the form so you can segregate something out, really, like there's a checkbox that says this is qualified expenses, and the machine can read that so we don't torment that taxpayer, that's something we could get into the works for programming. So that would be a very good issue to bring to us, and thank you very much. Please email me that, because we'll get to work. And they'll also call you, both of you, to talk about what my staff will. Great, I've got two
Wonderful.
issues to go. People hate when I come
Is this mic on?
on?
Thank you. Let me just say that it's refreshing to hear your perspective as you speak about longstanding cases, old cases. Of course, we're all whispering to one another. We know what it feels like to, as we call, unstick some of those old cases, where really through your intervention, you and the cooperation of the agency, you get to do some big things. And I'm also pleased to hear about your Taxpayer Bill of Rights, but also it's also a reminder of how we often do our policy work. We sometimes go at it for years and try to make our case and bring examples, all the data that we need to try to move the needle on particular issues. Sometimes it happens quickly, sometimes it takes 7 years, but the goal is that we move the needle and that we can achieve some systemic change through our intervention. So I'm very grateful that you're here today, and thank you all. I'm going to come up and say a few things to you for a second, and then we're going to take a break. So thank you, Nina. Appreciate it. Thank you very much. So if the IT is on my side today, we are going to show you very briefly our Blue Campaign Out of the Shadows PSA, and then we are going to take a 15 to 20-minute break to allow for Director Leon Rodriguez to get here and get settled in for our conversation. So let's go ahead and get that PSA going, and we will plan on reconvening here at 10:40. Okay. We can view it. Let's see if we can get them.
The Blue Campaign provides a unified voice for those who oppose the heinous crime of
Can we
human
start it
trafficking.
all over again? Thank you.
Whether it's forced labor, domestic servitude, or the sex trade, it's time we open our eyes.
Sorry, I didn't even see you.
No one ever does.
Learn what you can do to help by visiting around us. Our vision is clouded by the very normalcy we take for granted. Countless victims of human trafficking walk among us, seemingly invisible. until now. The Blue Campaign provides a unified voice for those who oppose the heinous crime of human trafficking. Whether it's forced labor, domestic servitude, or the sex trade, it's time we open our eyes.
Sorry. I didn't even see you.
No one ever does.
Learn what you can do to help by visiting dhs.gov/bluecampaign.
Thank you again. We have additional information about Blue Campaign. We have Blue Campaign staff members here with us as well if you would like more information about human trafficking indicators. And we will convene back here around 10:40 with the goal of starting our conversation with USCIS Director Rodriguez at 10:45. Thank you.
No mics are working. There we go. Thank you. All right, welcome back, everyone. We're going to get started with the rest of our program. So if everyone could please take your seats and please move in. I just wanted to issue a friendly reminder that at the end of this discussion, we will have an opportunity to take questions from the floor. You have index cards in your folders if you'd like to write down your question during the conversation and pass it over to our ushers. You can also wait until the end where we will have microphones that we can pass to you as well. Thank you. And now I turn it over to our Ombudsman to start her discussion with the Director of USCIS, Leon Rodriguez. Thank you.
Hello again, can you hear me? Great. I think we're on. Our staff probably are preoccupied whether our mics are on or not. They're on now. They're on now. Welcome and good morning. Good morning, Director Rodriguez, and welcome back to everyone. I'm very excited to have the new leadership of the USCIS here with us. I see many of your career leaders and also some of your new leadership team here as well. And maybe before the end of the morning, we can introduce them. I wanted to say that you're the new USCIS director, but truly after, 5 months now, you're almost tenured. Managing an 18,000 person operation as complicated as USCIS really makes you tenured pretty quickly. But I want to, in front of our stakeholders, say welcome. Welcome to our conference. And it's been a pleasure to get to know you over the past few months. And I am hopeful that over the next couple of years, we're going to get a lot done. So I look forward to this conversation. I appreciate your candor. And I have heard you articulate some of your plans for USCIS. And I look forward to hearing more about your vision for the agency today. If you don't know about Director Rodriguez, let me tell you that he has previously served as the Director of the Office for Civil Rights at the Department of Health and Human Services and as Deputy Assistant Attorney General for Civil Rights at the U.S. Department of Justice, where he had a long and distinguished career. I think Director Rodriguez's public and private sector experience is truly an asset to USCIS. And please join me in welcoming Director Leon Rodriguez today. So these folks probably don't want to hear any more from me. I've been talking for a while this morning, and they're eager to hear from you. And it's been a few months. Can you share with us what your experience have been and your impressions of the agency so far?
Sure. Thank you, first of all, Maria, and all of you for such a gracious welcome. Actually, believe it or not, I've only been in the job for 4 months. But take comfort, I was in the deep end of the pool pretty much from day one. It really is a huge and important job that we do at USCIS. One of the memories that's always going to stick with me from those first months was being at my first naturalization ceremony as director. And right in front of me as I was administering the oath was a young man from Nigeria who, at the moment when he said, "So help me God," to conclude the oath, looked up to the sky and raised his hands and breathed a sigh of relief. And what it brought home to me, and I am, as I think many of you know, the son and grandson of immigrants. My parents came to the United States from Cuba. My grandparents came to Cuba from Eastern Europe and the Middle East. So the migrant experience is a huge part of our life. But any immigration benefit, any time that an individual applies for and receives an immigration benefit, that is a life cycle event in the same way that a wedding is, in the same way that a graduation is. That is a life cycle event for that person because if we're talking about a family visa, that means now where a family could not be united before, now they can be. If we're talking about something like an H-1B, that suddenly means whole new opportunities for a family. And so that's just like any other life cycle event, and I recognize it as that as director. And one of the things that I've been heartened to see, and one thing that I give a lot of credit both to the USCIS staff, but also to now Deputy Secretary Mayorkas's leadership, is that we call the individuals with whom we interact, we call them customers. We don't call them aliens. We don't call them applicants. We call them customers. And it really is evidence of a recognition that what people are coming to do when they come to USCIS is really to move their lives forward, to become part of the great American dream. And the one thing I always want to emphasize is immigration really takes all of our values, all of our needs as a society, and really it all funnels into the policy calculus we engage in immigration. So first of all, it's about our values. What are we going to do for individuals around the world who are victims of oppression? It is about our needs as a country. What is an immigration policy that country, and many other issues. All of them feed into immigration policy. So we bring that lens to what we do. What I have found in terms of what I've seen in CIS is a highly qualified workforce, a highly committed workforce, but also one that is juggling huge caseloads, one that never quite has all the resources that it needs to be able to do its job. And so part of our balance as leaders is to find those efficiencies, find those opportunities to help our people be able to do their job better. I know that one of the concerns that will undoubtedly be expressed today are issues about our processing times and about the burdens that we place on commissioners, and those are concerns that I share and that the staff shares. We want to make the customer's experience as smooth an experience as we can. And that's why the feedback that we're going to receive from so many of you is so important. I'm particularly gratified as I look at the list of who's here today, that there are so many of you who come from community-based organizations. I'm a former board member of CASA de Maryland. There may be somebody in the audience from CASA here today. And we understand that where the rubber hits the road, is those of you who are really interacting with those individuals who will eventually become our customers. So I'm really looking forward to the feedback that you'll all share.
That's terrific. Thank you. I am curious. I joked at the top of this conversation about just the size of the organization, but you just alluded to just the breadth and the scope of what you do in the areas that you touch: business, immigration, humanitarian. How do you prioritize? What are your top priorities at this point? What's at the top of your to-do list?
Well, I talked about one of them, which is certainly looking in a holistic manner at the customer experience. So it is looking at, one, cost. I know that that's always a concern. Looking at processing times, looking at the burdens we place on our customers, looking at issues related to language access and cultural sensitivity, and seeing where our opportunities are to do even better in those areas. The other big areas of focus are, first of all, it is no secret, the President has made very clear that in the wake of a failure by Congress to give him a comprehensive immigration reform bill that he can sign, he is, sometime between today and the end of the year, going to take action. And so I certainly see as a priority for when that time comes to be ready. To make ourselves ready as the different elements of that action start occurring, that we be ready and that our folks be fully equipped. So that's certainly going to be an area of significant priority for us. The second area is you look around the world and the need for refuge has not abated. Last year we reached our pretty close. We were just a handful of folks away from our refugee ceiling. And so you look at what's occurring in Iraq, you look at what's occurring in Syria, and those needs, and in many other places around the world, and that need for refuge has not abated. And so we need to continue to offer refuge, but as we do that, we also need to be acutely aware of the national security risks that arise in that particular area of our business. And so we're going to continue to do our job there. We have a very strong fraud detection and national security director. And so we're going to continue to make sure that we strike that balance exactly right between humanitarian objectives and national security objectives. And then finally and this kind of goes back to the first thing I mentioned about customer experience, is really continuing the re-engineering of our business processes. That is, a lot of the discussion around that has focused on the transformation of our information technology infrastructure. That's something that affects both our customers and our employees, and the goal of which is to make things smoother for both. But I think it's important to think about that as part of our overall business process. It's not just what the machines do, but it's also about what the people do and how they do it and how easy we make it for people to do things. So that's an area where, whenever it is, and my hope is to be doing this job for a very, very, very long time, but whenever it is that my time comes to go, that I leave seeing sort of the light at the end of the tunnel of that process, that we know how it is that we're going to enter into the next generation, that we're going to do it as an improved organization, a better experience for our staff, a better experience for our customers.
Thank you. I have spent a lot of time over the past few years visiting USCIS operations. I have learned a lot about operational constraints, about the shifting of resources to accommodate a higher number of receipts, new programs, and priorities as determined by both the director, the department, and our administration. Yet I want to go back to customer impact, because I think that we can spend, and I think everyone should be encouraged to learn more about how USCIS operates and some of the operational challenges that Director Rodriguez just alluded to. We focus on customer impact. That's like the core of our mission. And one of the main complaints that we hear from customers is related to processing times. We have given feedback to the agency about how we think the agency can improve processing times, the way it calculates them, the way it posts them, and transparency to the public on what kicks you out of processing times. And I'm wondering, do you have any thoughts about changing the way USCIS calculates and posts processing times?
I mean, I think that's an issue that we need to continue to look at and continue to try to do better. I know we've moved, for example, we used to be in a 45-day cycle of posting or processing times. Now we're at a 30-day cycle. But you look at our business, and those are 30 very long days in the sense that all kinds of things affect our processing times. So we're going to continue to examine opportunities to do better. I think our technological transformation provides a real opportunity eventually to be in a place where we can be pretty close to real time in our reporting of processing times. And I know how important that is for our customers, because you're planning all kinds of things. You're planning your job applications. You're planning travel. You're planning all kinds of things based on that knowledge of processing time. So, I mean, I think we recognize that this is an area where we want to do better. Whether we're going to get there tomorrow or whether it's going to take us some time to get there is the one thing where I'd want to sort of manage expectations, because I think it's going to be a long process to get to really an optimal state in this area.
I think that would be terrific, and many people around this room will agree. It would transform the way the customer, understands how the agency operates, but also allows them to plan, better plan, and really understand ultimately where am I in the process? Because it says, I just applied for my DACA renewal, and it says 120 days, but it's been pending for over 120 days, or my family petition, it has been pending for over a year, but the processing time say 6 months. Why is my case outside processing times? So one, is there a way to improve it? Two, is there a way to better inform the public? I have a question about requests for evidence, because that's another chief complaint that we receive, and that is an area in which folks will see their cases kicked or trumped out of processing time. So you receive a request for evidence from USCIS, that tolls processing times. We receive complaint after complaint about requests for evidence that are sometimes unnecessary or just overly burdensome. Recently, USCIS has shifted to an initiative focusing on quality in the workplace, and I'm wondering if you can share with us what your understanding is of that initiative, but also how we should expect it, hopefully, to improve consistency and quality in adjudications. I just wanted to give you the RFEs as an example of an area where quality could improve.
I mean, I think the first important thing to say about the quality workplace is that it should never be seen that quality is the enemy of quantity. And I think one of the concerns for many different quarters as we got into the idea of quality workplace was that somehow our pace would suffer. That as we sort of strive to do sort of the prettiest possible adjudication, that we would somehow our times would suffer. That hasn't been the case. That's not an impact that we've really seen. There are other things that drive when our processing times are suboptimal. There's all kinds of things that drive that. RFEs are an interesting area, and recently I delved into an interesting example of the phenomenon that can happen, and this is why this is always going to be an iterative process, and this is why your role is actually so important as the Ombudsman and the role that you all play in giving us feedback. We saw an example recently of an area where an applicant essentially presents two different bases that will qualify them for a particular benefit. I'm not going to necessarily highlight what that particular benefit is. And the petitioner has it cold on one of those two areas, which means the petitioner now qualifies for that benefit. But then we see an RFE for the other qualifying element. The question that you ask yourself is, do we really need the evidence of the second qualifying condition at that point, or can we go ahead and grant the benefit now? And that is an area where what we want to do with our folks is to equip and empower. We need to equip them, train them so that they understand their role, the law, but then that they feel a level of empowerment where they can make that judgment to say, I have enough now to approve this application, and I'm going to do it. So that's a process that I'm certainly going to be promoting as director. Now, there are going to be RFEs, as you well know, that are going to be legitimate RFEs, and those do have an impact on processing times, and we certainly don't want to inhibit our folks anyway from doing the ones that need to be done, from putting the ones out there that need to be done. Now, as far as overall processing time, and I know there's a specific concern with DACA, our sense of it, or the information that we get back so far, is while there are outliers, folks getting very close to that, very close to the expiration of their EAD, in fact, we have been overwhelmingly within processing times on those. We do, note the importance of adhering to that 120-day time frame to really have that assurance, that comfort that the application is going to be processed in time. And that, of course, again, the RFE plays a role in that situation as well.
They do in some cases. And with regards to DACA renewals, I know we are early in the process of renewing DACA, and I think there are some folks in the audience who may have questions about that. We have seen a number of cases coming to our office in which the applications for renewal have been pending in excess of 120 days. So we will continue to work with you to highlight those cases, and especially when individuals face hardship, including losing employment. I want to ask you to clarify an announcement that was made back in August when after DACA was rolled out, that there will be temporary approvals for those individuals coming up on expiration who can show certain hardship if it's not renewed timely. Can you share your thoughts on that and whether that's going to happen?
Yeah, no, and I understand. And by the way, I don't want to, make sure not to neglect this side of the room. I know that there was a lot of confusion that arose out of I guess, an engagement that occurred back in August. We have FAQs out now that make clear that there will not be temporary employment authorizations in this category. What we are going to be focusing on is making sure that they get done in time. People who are right at the line of that, where their EAD is expiring, can submit service requests at that time. So far, all the we keep checking this issue practically daily now. And so far, everything that we've been seeing is overwhelmingly that we are actually meeting the times. We've had a few cliffhangers, and I think that's important to acknowledge. People who are getting their card, a day or two before the expiration. And I think that, I recognize that that's probably fed a lot of anxiety out there among our customers, and that's something we'll continue to watch and try to see how we can minimize that.
I think that would be great, and I will ask you a follow-up question. Will the agency consider adjudicating those applications within 90 days instead of 120 days, consistent with how other applications for employment authorization are treated?
We're always open to re-examining the way we're doing things. For the foreseeable future, we should all assume that 120 days is the required time frame. I really, especially those of you who are working with individuals out in the community, that 120-day time frame, I think, is really important for us all to be operating under the assumption that that's going to be the time frame for the foreseeable future.
The department has spent a considerable amount of attention and resources addressing the large number of unaccompanied children coming to the border. On our end, we monitor the adjudication of special immigrant juvenile petitions, and I would like to ask you to address some of the issues that we've seen, going back to the request for evidence question regarding the adjudication of what we call SIJ petitions. They have to deal with the USCIS's interpretation of its consent authority to go behind the state court record to see whether that state court order was issued only for the purpose of obtaining an immigration benefit. We're seeing much inconsistency across the country in how these applications are treated, and I wonder if you're prepared to give us some thoughts on that today.
Sure. And I actually come to this from a special perspective because, as I think some of you know, I was the county attorney in Montgomery, Maryland, County, Maryland, just up the road. And so one of my clients was actually the Child Welfare Office in our Department of Health and Human Services. So I actually saw this issue from a different side, or different lens. And I was actually lucky because I had one of the great clients. This is really one of the top child welfare outfits out in the country. So I have an understanding of what they do and what eventually leads to these court orders that support the special immigrant juvenile petitions. There are specific characteristics, specific findings that we require the family court judge, the juvenile court judge, whatever the case may be, to make in order for a child to qualify as an SIJ. And there needs to be a finding of abuse, there needs to be a finding of neglect, and there needs to be a statement of facts in that determination that satisfies that one of those elements of the SIJ has been found. What we sometimes get are very summary court orders that make unclear what kind of finding, or that leave unclear, leave uncertain what kind of finding that judge has made. And it's in those cases that you'll find our staff looking behind. That, by the way, makes sense to me. I'm looking at it as a new director. That approach makes sense to me. Now, what I think we need to do, and a discussion we've certainly started having, is that if we're not getting orders that look that way, then I think we would do well to be engaging with family court judges, with welfare agencies, with the National Association of Counties, the International Municipal Lawyers Association, as the case might be, so it is understood that the consequences of having these very summary orders is that then will have a potentially adverse consequence for these
For me
kids.
is how far behind the record? We have seen requests for evidence that call for transcripts, every document, every filing, all testimony, everything that was presented before a state court. Given particularly, leaving the really how broad is USCIS's or not USCIS's consent authority to request those. Given the constraints in the juvenile justice system and the fact that many of these children are served by charitable organizations, how much of a burden should be shifted to them to provide information that many argue is not necessary?
I mean, so look, that's an issue we can go back and examine. Here's going to be the challenge, which is, if you have that court order that doesn't say what it needs to say. It doesn't make out the elements that will enable that child to qualify as an SIJ. We don't know where the evidence is going to be. So it might be in the transcript. It might be in some more detailed order that's in the court file. We don't know, and so we don't want to leave a stone unturned that's going to enable that child to qualify for that benefit. Can we be more tailored? Maybe we can, and that's certainly something that we can examine. Is that to find some standardization, to find some economy in the way we do these RFEs to see. I know, for example, if I was an attorney representing that child, I'd want to make sure that I gave CIS everything I could to make sure that this was satisfied. I'm also mindful of what the burdens would be on both the children and their advocates from these requests. We can look at that.
Sure. That would be fantastic. And I think the Ombudsman's Office has made a prior recommendation to centralize the adjudication of special immigrant juvenile petitions. It would be recommended that it be held where other humanitarian applications are adjudicated, the Vermont Service Center. So going forward, we will continue to flesh out that recommendation for your consideration, and hopefully we can continue to work together in that area.
So if we adopt that recommendation, do I get to go to Vermont?
We get to go. We can
In
go
the
together.
winter.
That would be great. In the
Awesome.
winter, that's
Okay.
the only time my deputy says I can go to Vermont is when it's snowing and it's cold.
Okay. Okay.
Oh no, wait, that's Miami. He said I can only go to Miami when it's cold in Miami, not in the summer.
Oh, it's never cold. I'm from Miami. It's never cold in Miami. So
I'm not allowed to go to Miami. So for many years, we're not. Asylum, can we switch to asylum?
Sure.
Let's talk a little bit about asylum. Many of you in the audience work on asylum matters, are familiar with the challenges of the past couple of years where we have seen the waiting time for asylum interviews really escalate to a very long period that is reminiscent to me to the early 90s when I started doing this work. And it would take you 2-3 years, sometimes 4 years, just to get an asylum interview. Now that we had made a lot of progress in that area, we're seeing that due to the high number of credible fear cases, resources have been diverted from affirmative asylum to credible fear. Can you please inform us, help us understand what plans are there in place to address the lengthy affirmative asylum backlog?
Sure. So let me start by sharing a heartfelt, So this is a tough area. I think you understand exactly how we found ourselves in the situation we did with the sudden and pretty dramatic increase in minor children now applying for asylum. Everything that I see shows that trend is going to continue and possibly grow for a while, for a good while. We've done a few things, and we're going to do a few other things to help us. One, we're concentrating energy in particular cities to be able to move those cases expeditiously. Hopefully, that'll eventually enable us to return to more normal processing times on asylum. We've added 50 asylum officers since probably roughly the last year. I'm looking at a request right now to add even more asylum officers. So those are all different solutions that we're looking at. We know that eventually we need to get this line of business back to normal processing times. We know that this both is a significant burden on legitimate applicants who have to wait longer than they should for employment authorizations. It actually also exposes us to fraud. The longer, the more broken down this system looks, it exposes us to fraud. So we know we need to find a solution, and we are working to make sure we mobilize our resources in a way that provides us. That's going to take some time because the amount of pressure that has come on the asylum system is just that significant that it is going to take some time before we're able to really get this back where it should be.
Thank you. You guys want to ask some questions? Should I stop for a minute? I have more questions, but I know you have many. So why don't we go to the audience for a minute? And if you have a question, you can walk down to the mic. If you can't get out of your seat, Fred can hand you the mic. And Carly Salazar is over here as well.
So we're talking about the rollout of E-Verify self-check. Status and experience so far. Can you comment on that? Any new initiatives?
Yeah, we're still at the very early part of that process. It looks like something that's going to work very well. I think I still want to watch it for a little while before I give you a real status. But so far, it looks really good. It looks like it's working very well.
We have one question here on the left.
Good morning, Director Rodriguez. I have a question in terms of going back to the DACA renewals. What do you recommend that applicants could do to talk to their employers or to keep being employed before their expiration date expires? So if there's, for example, within a few days and they haven't heard back yet, what do you think that they should do because there won't be issuing any more temporary permits?
Yeah, I mean, I think the main thing is, one, they can't, if you're still authorized to be employed, they can't let you go. That potentially raises legal issues for the employer to let you go on that basis. The fact that the one thing that I will say, and that should certainly be repeated to employers, is that we are meeting our processing times on these. So that individual will have their card absent RFE issues, absent late applications. That individual should have their card within the processing times. It shouldn't be the case that 8 days before the expiration, individuals should be let go on the basis that they don't have their card yet. That potentially raises a very serious issue for the employer.
Hi, my name is Kate Boyd. I work for the American Immigration Lawyers Association, and I kind of wanted to follow up on the processing times for DACA. You mentioned the 120-day processing time, but I think that's really the first we've heard of that, and the first the public has heard that that is the processing time. From what I know of the processing times posted to the website, it's at 6 months, which is actually the processing time for initial DACA requests. So that provides actually a host of problems to DACA renewals. People can't follow up on their cases until 6 months, and if you post the processing times as 120 days, then they can't follow up on their cases until 120 days. Well, at that point, their DACA has expired, and they no longer have work authorization.
So one of the things that we're watching carefully is the correlation between the status of the application and the actual expiration of the employment authorization. And so we know that that's the target that we need to meet. We've been meeting it within the 120-day time frame. So even though 6 months is this sort of official thing that we have out there and that maybe needs a look-see as to whether that inconsistency should be there, the fact is that the way we're working is that if we have an application that is trouble-free, in other words, it doesn't need an RFE, the background check comes up fine, those are applications that we're working to take care of within 120 days, and certainly in time for the expiration of that individual's EAD. But I do know that's a little bit of an awkward inconsistency that's there.
Well, and I think one of the important processes that we've seen is that there are always going to be outlier cases, and having a way to follow up on those cases is key. And the way the system works now with USCIS, it's very difficult to follow up on those cases unless they are they're outside of the posted processing time. So that's sort of a trickle effect that I think is very problematic.
I certainly encourage individuals to use our customer service operation to register concerns about those issues. I've actually just a couple weeks ago was up in New York looking at one of our centers up there. We have a lot of great people, immigration services officers working in our customer service centers, and that's certainly a resource that I would use in those kinds of situations.
I have 2 questions for you. You hear?
Yep.
2 questions. First question is, in light of the recent decisions in the 6th Circuit and Western District of Washington that have created inconsistent results, does USCIS intend to issue guidance on whether aliens who entered without inspection and later were granted TPS are eligible to adjust to LPR status, when they meet all other visa criteria?
Can you say that all over again?
It is. This is a very informed person. So there were some recent decisions in the Sixth Circuit in the Western District of Washington that has created some inconsistent results. So the question is, does USCIS intend to issue guidance on whether aliens who entered the country without inspection but later were granted TPS will be eligible to adjust status to legal permanent residency if they meet all other requirements?
Yeah, so what I will do is this, make sure to assess the premise of that question, which is that the Sixth Circuit, the Western District of Washington decision leaves an inconsistency and inclarity. If it does, then we'll go ahead and post some clarification that will...
They put the names of the cases on the card, so I'll give them to your team.
Bring it on. Those issues have been in the back burner now for some time. The issue of whether someone is eligible to adjust when they're granted TPS, because the regs do allude to the fact that they're not in non-immigrant status, but also when you travel on advanced parole, if you have TPS and you return, then what's the impact to not just your entry, but your ability to adjust your status later? So we look forward to working with you and with your team on those issues. They've been on the back burner now. We need to move them back to the front burner.
My second question that I have is, you mentioned that President Obama, between now and the end of the year, is going to take action. What actions do you think these may be?
Does anybody not have that question?
I love that all the questions are for you. That's great.
What I can say about that is this. Think of it in the framework of we have an immigration system, and when I say immigration system, I don't mean the people that work for me in USCIS and the other agencies that are involved in immigration, but a structure of a legislative structure for immigration that's not working, and that's something that the president will use his tools to address. What the specifics are, I would make no assumptions right now about what those specifics are.
Hi, Director. First of all, I wanted to, Sheldon Zeligan, a member from New Jersey. I wanted to thank Maria, first of all, for allowing us to have this conference, and your coming. Information is extremely important for all of us, and to get this out to our clients and stakeholders is just extremely important. My question goes to the area of naturalization. My parents are immigrants also from Europe, and as you said, it's the ultimate life cycle event. I wanted to, first of all, compliment you and previous director on your public engagement area. It's an exquisite area that gets outreach out to everybody. You mentioned also language access. So I know that you're having an outreach on citizenship in Michigan, which is very, very important. What other, for the election year coming, and I've always had, I follow this, we've got 9 million or so lawful permanent residents, and only every year 700,000 seem to apply. So there's got to be, and we've tried all sorts of different ways. I love naturalization. The ceremony that you talk about, there's nothing better than going to a naturalization ceremony. So I compliment you on your public engagement team. Mariel is unbelievable, and now Carlos. She's just great, and because she gives people information to work with, and that's just vital. So what do you foresee as things that we can do to get more people to apply for naturalization, knowing that it really makes you part of the country?
I think we need to continue to look soberly at what are the reasons why people don't naturalize. I actually, my parents naturalized the very first minute they could. My grandmother took 25 years, and I couldn't tell you, to this day I couldn't tell you why she waited that long. I think there's all kinds of reasons why people don't. But we need to continue to examine cost. We need to continue to examine the burdens involved in the process and degree to which they naturalize. We also need to remind people of the benefits of engagement. One thing you get when you become a citizen is you get a vote. And I don't mean that, I really don't mean that in a partisan way. You look across my family and we have naturalized citizens at the very far left and the very far right of the spectrum. So this is really about everybody exercising that franchise, and that's a really important consequence of citizenship. One thing that I would love to see, and we certainly are ready to work with them on this, is the for-profit sector stepping up. There are some great examples. There's some work, for example, that the National Immigration Forum is doing in this space to work on employer-based programs. I think these are great opportunities not only for companies with their employees, but also with their consumers. Because the reality of our country is that a growing demographic are immigrants eligible to naturalize. And so that's a great business opportunity in the for-profit sector. I certainly support the work we're doing with immigration, with citizenship grants. I want to see that continue. We're going to be advocating for that continue and to find other opportunities to give those kinds of grants as well. Thank you.
I love that you're asking that question after the election, because it really should be a question that we ask ourselves year-round. And in addition to what the director has just shared, I think given my prior hat, and I know that many of you working for charitable organizations, you're thinking, we have to have a sustainable approach to providing legal services in the area of naturalization as well. And that includes private sector engagement, pro bono partners, but also includes long-term investments, not just in naturalization, but immigrant integration. And I think that your point is well taken, and I hope you bring it back again and again and again, not just the day after the election, but throughout the year. Yeah. I'd like to ask a question real quick. My turn now, but don't go. I wanted. Can we switch to the Administrative Appeals Office? I think it's on some people's minds here. And in our last annual report, we were able to release for the first time data pertaining to the adjudications done by the Administrative Appeals Office. And it left us scratching our heads a little bit. There is, I think, a widely varying appeal or sustain or approve rates depending on categories. Some categories you see high rates of decisions overturned by the AAO, and some you see very large percentage of applications sustained. And I say I was left scratching my head because either USCIS is getting it right in some application lines and not others, or there's disparity in how the AAO approaches various application lines. Can you share your thoughts about the Administrative Appeals Office? Have you thought about whether it is as independent as it is charged with being, or any other concerns you have about its ability to be independent?
Yeah, I would certainly say that my observations to date, to answer the last question first, my observations to date are that they are independent, that they are not influenced by the field. Now, their job is to make decisions on law and policy. So at the end of the day, I certainly play a role in those kinds of decisions, and our general counsel's office plays a role in those decisions. But we certainly don't want it driven by where those appeals are coming from. I think what you're finding in terms of different rates of either affirmance of the field decision or reversal of the field decision is a point of evidence. But I would not want to treat it as the sort of defining point of evidence, because there's a lot of factors that may play into why there are differences either across different lines of business or different locations. And at the end of the day, these are meant to be case-by-case decisions. So we certainly don't want to be looking for there to be a magic number of affirmances or anything like that. We want these to be case-by-case decisions. So what we really want to be looking at, and what I'm certainly going to be examining, is the process be, as you suggest, independent, that there be a high level of technical expertise brought to it by the officers in the AAO, and that there be a level of diligence and integrity to what they're doing. That's the thing that we look at. Again, for me, the affirmance rates or the rejection rates, that's more a point of evidence to be considered, but it wouldn't, for me, drive the whole analysis of what's going there.
Thank you. I appreciate it. It is a factor, and I appreciate hearing that it will be a factor, perhaps a factor that can be considered as you evaluate the function of the AAO, and hopefully adjudicators are empowered to make the right decisions based on the evidence presented before them. So I think that would be a good thing for the AAO, and maybe other folks in the audience have thoughts about that. Okay, I'll stop and turn it back to the audience.
Thank you. I'd like to go back to the question of the RFEs and the burdensome RFEs, and not approach it not necessarily from a perspective of processing times and efficiency, but a question of policy. Those of us who practice in the business immigration world have seen the RFEs over the last couple of years, particularly in the H1 and the H1B and the L1B areas, reflect a more restrictive policy that seems to be moving the bar more and more restrictive, both in the definition of specialized knowledge and in the definition of specialty occupation. And I'd like your views on that issue. I know that we've been talking about policy pronouncements that are going to be coming shortly. Shortly, of course, is a term of art that we haven't yet been able to define. But if we could get your thoughts on that, I'd appreciate it. Thank you.
Sure. And I guess for me, I don't necessarily, I'm not ready to accept the idea that it reflects a policy change as much as at least a perceived trend in practice that needs our examination. I mean, I've heard this, especially in our engagements with AILA, this is a concern that comes up often, that the bar has sort of gradually moved. And that's something that I think we still need to examine why that is. I don't think it specifically represents a change in policy as much as a sort of gradual migration of practice. And whether we need to right course it, I think is something we still need to pay some attention to, which is why that feedback is very important.
I'm going to sneak in another index card question before passing on the mic. This individual writes, I've respectfully asked this question at conferences for years, including to other USCIS directors, and would like to know, for O visa business employer petitioners, is there any attempt to limit the difficulty of procuring a relevant peer organization no objection letter or support letter? Anything on the horizon for that?
That actually is an issue. Again, I think the question was the term of art shortly. What does it actually mean? We are looking at the O visa requirements right now as we speak, and whether there's any clarification required that is mandated. When that's going to come out, I wouldn't predict it specifically, but we are trying to get that done in short order.
Good morning. If I may add, if that stakeholder can write on the back of that card what specific issues you're seeing in that area, it would be helpful as opposed to asking when. I think it's what who can be an objector and what the content of that objection needs to be. I suspect is the issue. Is that what that card suggests?
That was the issue, because oftentimes I'll get RFPs or I need to get a peer organization when one doesn't exist, or I find myself trying to sometimes be a used car salesman, calling up organizations, trying to get them to look at someone's file if they don't even really care about it.
Yeah, and I think that is one of the interesting things about O visa, and we recognize this, is that the kinds of individuals that can enjoy a job, that's evolving. So the one that was presented to me almost the day we walked through the door was this idea of, if you're in a reality show, what's the professional organization for somebody who appears in a reality show? I don't know. Or there is one. Maybe you guys know which it is. But we recognize that for example, the entertainment industry is evolving in a way that requires us to take a look at whether our historical models really do make sense. And there is a group in our office who's actually looking at these issues, these very specific issues right now.
Okay, good morning. My name is Alicia Flores. I work for La Hermandad in California. And my question is regarding DACAs. If a DACA comes with an advance parole and married to a U.S. citizen, are they going to be able to adjust since the last entry it was inspected?
I don't unless there is an independent basis to qualify for citizenship, that advance parole will not qualify an individual for citizenship. I think that's the question you're asking.
Yes, that's the question.
Yeah, I mean, unless there's an independent basis, again, to qualify, for example, some eligibility for family visa. There's some interesting evidence out there that a not insignificant portion of our DACA recipients actually have independent bases of eligibility. That's something that I actually think for citizens, for immigration benefits, that's something that I think merits some examination both on our part but also out in the community. Obviously, DACA is an impermanent benefit, so if individuals are eligible for more permanent benefits, we'd certainly like to see them qualifying for those.
It's like the TPS, so it's not going to be the same scenario.
Not the advanced
with the
parole in and of
DACAs, it
itself.
won't. Okay, thank you.
I think it would give individuals, I think, peace of mind before proceeding to, one, travel abroad, but also to file for an adjustment application upon return, to have clear written guidance on whether an individual who travels on advanced parole, who was previously here without status, had previously entered without inspection, who travels with an advanced parole, whether they have DACA or TPS, can later adjust their status upon return.
Again, it certainly wouldn't be a bar to later adjusting, and I guess that's the clarification that you're talking about. We can see what we might need.
I think we have a follow-up comment up here from our office.
I think the question, is she positive, if I heard correctly, was the individual is married to a U.S. citizen and is returning on grant of advanced parole. So a DACA recipient has advanced parole and marries.
Yeah, the advanced parole would certainly not be a harm that person. I think is that the essence of the question? Is whether the
question is whether, in order to adjust under 245A, you have to have been admitted or inspected. That was the earlier question about the Sixth Circuit case, Flores, that a TPS, a grant of TPS was considered.
I see. I see the question.
Is now somebody in DACA who departs and returns on advanced parole, have they now been admitted so that they're now eligible for adjustment under 245?
I think we owe some clarification in that area. I think the answer remains no.
Yeah.
No. The question is what other relief, what other pathways might be available for those individuals, and that's something where I think I wouldn't go beyond that today.
There's Board of Immigration Appeals precedent in this area, and this is an area where we have been waiting for guidance. I think is evident by the fact that all of us who have been paying attention to this issue, and I'm sure you have been briefed on, are waiting to get some concrete guidance on whether those individuals should plan on using that advanced parole, to later adjust as they're eligible. So I guess it's a resounding yes. We need additional guidance.
Yeah, I mean, right, because right now I think the answer to the question would be no. Whether the answer should be different, I think, is where the guidance needs to come in. Okay.
Thank you.
Yes, Director. We have a question here that really raises the attorney-client relationship and the interaction of attorneys and USCIS officers in field offices when the attorneys are there presenting themselves as the client's representative, and the adjudicators or the officers at times not recognizing the attorney and engaging the attorney or allowing the attorney to engage. It's a question that goes to that relationship, and we've heard this over the years. It's not that it's systemic, but it's an issue, and I just want to put it out there. It's one of the questions that was asked.
Yeah, I appreciate you highlighting that issue. I know that it's been an issue over many years. As I understand the issue as presented by the staff, it's usually a question of whether the appropriate documentation is on file for the attorney as representing the customer. If there's a different issue that's coming up, I would like to know. I would like to hear it.
Let me clarify. It's when an attorney is present with a G28 on file in an interview, and the question is the professional courtesies and representational rights that the attorney has with his client to engage the officer and the officer to engage back with the attorney in that scenario.
Okay, I mean, again, as a matter of general policy, we obviously recognize the eligibility of the attorney to represent that individual and to act on behalf of that individual. Undoubtedly, in a field office, there are circumstances in which we need to communicate directly with the customer. That line, my suspicion is that this comes up in situations where that line is a little bit unclear as to what needs to be directed to the customer, what can be handled by the attorney. We'll certainly watch that issue and try to make sure we get it right.
As just a follow-up with that, if an attorney has that situation and they're presented with a scenario where they believe that the officer is not allowing them to engage in a way that should be appropriate, in that attorney's opinion, how would you suggest they approach that?
I think this is a great subject to. I don't know if you work or you're an ALA member. And,
No, I'm on the Ombudsman staff.
He's reading.
Okay. But I think this would be a great issue because I think the question is, what are the specifics? What are the scenarios in which this is occurring? If it's an area where we need to provide clarification for our staff, then we'll do that. If it is an area where we need to provide clarification to the bar, then we'll do that. But a lot of it depends on what is the trend here? What are the circumstances in which our field officers are declining to speak directly with the attorney and instead are trying to, are communicating with the customer? It depends on the specifics.
So I think that's a call to us to get some examples, perhaps, from the Ombudsman's office. One other question that I've had 3 cards on, and it's all about what is USCIS doing, if you can say, regarding planning for any executive action.
What I can say is this, is that we will make ourselves ready when we get the order from the President. And that's all that I...
Doing a time check, we have probably 5 more minutes.
Okay.
We're still waiting for the Secretary, so we'll get an update shortly.
Hi there, thank you. My name is Eric Thejedin, and I'm the Associate Director of the Immigrant Children's Legal Program at the U.S. Committee for Refugees and Immigrants. And my question comes from a perspective of trying to reconcile our immigration policy with the family reunification and humanitarian interests of the United States. And my question specifically is about non-immigrant status. Over the last 3 years, we've reached the cap. And although you have the principles being placed in deferred action, it's created essentially a waiting period for derivative family members outside the country. And my question is, what is your current perspective on our position on either raising the cap, eliminating the cap altogether, or perhaps borrowing from another visa category to satisfy, again, the humanitarian interest and family reunification interests of the United States?
I would say that my perspective is a perspective of openness. I certainly recognize the importance of U visas and encouraging the kind of activity that make people eligible for U visas. And that's what I would say is we're certainly open to taking a look at that issue.
I have a question on this side.
I'm Erica Rodriguez. I'm a supervising attorney at Catholic Charities of Arlington, Virginia. OGAR Immigrant Services. We're one of CIS's grant holders for the naturalization grant, which we hold once a month. And my question is, if CIS is looking into revising the Form N-400 again, and I know there was a revision this past year, but speaking as the attorney that supervises our voluminous number of volunteer attorneys and non-volunteer attorneys at these workshops, it's been very difficult for me to communicate some of the confusions that the current form has that have been clarified in the tips that USCIS has issued in the interim in May and June. However, since they're not on the form itself, it's very difficult to communicate that because the tips are actually inconsistent with the wordings of the questions themselves, such as the have you ever been involved in asylum or genocide, and the question should actually be have you ever been a victim of either of those two things, and that's the actual interpretation. So and the additional question that's created a lot of confusion at our workshops is the selective service question, whereas you're really only focusing on the good moral character section and not actually requiring a letter at the time of submission of the N-400 and actually later. So those are two of the main areas that I can think of. There's a few others as well, but I'm wondering if you're looking into revising the N-400 as it would make it a lot easier to provide these services to the great number of people we serve?
I don't believe we are looking to revise it. I think these as you may know, these form revisions are big undertakings. So even if I said today we're going to revise it, it would be a long time before you would see a new form. There's all kinds of approval processes, Office of Management and Budget, and all that. This feedback, though, is critical because one, it gives us an opportunity to provide clarification. Two, when we hit that mass where this is not a form that's working anymore, then that's our signal that in fact we need to re-examine that form. Right now, no plans. Important feedback that at some point may lead us to do exactly that. Thank you for your question.
Director Rodriguez, I have 5 questions here, but we may only have time for one quick question. Regarding InfoPass appointments, it's been stated, will there be any improvements? It's almost impossible to get an appointment from the 24th District.
Before you answer that, maybe I'll add as well. I think responses to customer inquiries using the call center can sometimes be vague. A lot of times people will put in an inquiry about a case and they'll get a response that says, well, your case is pending. Well, we know the case is pending. Why is it pending? About how long will it take to get it adjudicated? Some people turn to the InfoPass process to go in person, particularly if the case is pending before the field office. What's your take on those 2 aspects of customer service and how the agency can improve its response?
Yeah, no, actually this is the first time I've heard either of these concerns. So actually they're ones that I'd want to examine. InfoPass I've always heard of is actually on the whole, mostly a very positive thing for our customers, and it avoids that 8-hour wait in line and everything. It looks like we have a very specific local kink based on that question. So we'll certainly follow up on that. And again, if there are issues in terms of customer service, we'll follow up, and if we can give more information than it's pending, then that's something that we'll do.
I've indicated before that InfoPass, I agree, it's a great success story for the agency. I remember working for INS and walking in the morning and seeing the line around the building and across the street and down the block and people waiting in inclement weather to be seen. InfoPass has brought about predictability, accessibility. In the beginning, people were concerned about whether people could go online to make appointments. Now USCIS has standalone machines in their lobbies where people can go make an appointment. A huge success story. I would leave this topic with a suggestion that InfoPass functions be adequately resourced, that it not be subject to the shifting of resources at a local office based on volume, that there should always be adequate InfoPass resources, adjudicators, experienced enough, who can always look at that inquiry with an eye towards resolution of that case. So if that customer is in front of you and that case is ready for a final decision, it's just delayed, that adjudicator has the capacity and is empowered to do that. And with regards to service requests, I know that there are many safeguards out in place now to look at the quality of the response to what you call SRMTs. I would encourage the agency to continue to do better because it creates a breakdown in the trust that the community has when they can get a meaningful response to their inquiry. Sure. Well, I think, okay, I can't leave you standing. Are you okay with one
I was
more question?
begging.
One more, absolutely.
Yeah. You mentioned earlier, where we were discussing earlier, the issue of how broad is the authority for SIJ looking behind the order? How broad is CIS's authority to do so? My concern for this area is that it will start to look like it does in the international adoption arena, where CIS, either CIS directly or CIS and its delegated authority through the Department of State, scrutinizes specific court orders with such high levels of expecting such high levels of clarity or asking and demanding such high levels of accountability that it doesn't actually take into account state systems or other country systems. Can we expect policy, something that will clarify adjudications and adjudicators' responsibilities when they are looking at applications that are based on predicate orders in general? Because it would be helpful for SIJ, but it is really helpful in any case where there is a predicate order that the whole adjudication depends on.
And when you use the phrase a predicate order, meaning one that lays out the required facts to qualify for that.
Right. 'Cause in the I-600 arena, the issue is, does this order contain all of the factors that meet one of the 7 grounds of orphan status? What we see at the NBC level, when those are filed with NBC, and what we see abroad when the Department of State is exercising this in its delegated authority from USCIS, so this isn't a DOS problem, then what we see is this real heavy scrutiny. And my fear, because I practice SIJ, but I also see what happens with international adoption cases, is that we will actually see more and more scrutiny of those. And from a lawyer's perspective, it undermines the judicial sanctity of that order. So can we look to maybe see whether there's going to be some policy generically about how we deal with those orders?
I'm not sure, and I'll tell you why I'm not sure. I'm not sure that the two areas are exactly analogous. There is a different family of concerns that are driving our review in the adoption arena than is driving our review in the SIJ arena. So in the SIJ arena, the question is, has the judge made the findings that are required by the statute? I think the concerns in that area might be different and more expansive. So I'm not sure I would necessarily analogize to the other. This does go to one of my very earliest comments about RFEs, which is, we do want to make sure that once you qualify, we stop. That we're not overburdening either ourselves or the petitioner. So certainly, feedback that suggests that we might be doing that is important feedback for us to be hearing.
Well, that concludes our conversation for today, and I really appreciate that you took the time to be with us and to answer questions as candidly and openly as you have, and I look forward to continuing the dialogue. So thank you all. Now let's do a quick time. Please, applause. Thank you.
To you guys.
Thank you. Thank you. Thank you very much. I'm hesitant to cut you loose, but I will for just a few minutes. Don't go too far. We'll go get a status update on the Secretary's arrival, and I don't see my thumbs up yet, so we get to take a break. Please do not go away. Stay within the vicinity. We'll inform you of his arrival very shortly. Thank you.
Hello? Can everyone hear me? I just want to remind everyone to stay close so that you can get to your seats pretty quickly. And also, I wanted to remind everyone that no food or beverage is allowed in this auditorium. Thank you. It'll be just a few more minutes. Okay, everyone, if we could have everyone please return to your seats. If everyone could please return to your seats in the back there. And if our ushers could let the corridor know that it's time to return to your seats. We'll be starting in just a moment here. Great. So I wanted to make a quick announcement that's very important. When the Secretary is done speaking, we do have some information for you that we'd like you to stay in the room for. So please keep your seats when the Secretary is done talking. I know it's right before our lunch break and we're all going to want to get out of here, but please stay behind so that we can, you can't, is the mic on? Okay. Let me repeat that then. So when the Secretary is done speaking, we just ask that you please stay in the auditorium. We have a couple of announcements that we'd like to make to you before you break for your lunch recess. And we're going to get started in just a minute. Thank you.
Great, welcome back. I think we are all now settled into our seats. Thank you and for coming back from your break so quickly. As you know, Homeland Security Secretary Jay Johnson supports our work across the spectrum of immigration functions here at the Department of Homeland Security. Under his leadership, the department has welcomed a number of new key leadership, including USCIS Director Leon Rodriguez, whom you met earlier. I hope you enjoyed our conversation and found it helpful. We look forward to our continued dialogue with Director Rodriguez. Secretary Johnson began his career as an assistant U.S. attorney in New York and most recently served as the top lawyer at the Pentagon. So I think he understands the law, and equally important, he understands how the law affects individuals. The Ombudsman's role lies at the intersection of law, policy, and operations. It is in that space where we evaluate all of these and how they come together for those trying to navigate the U.S. immigration system. I appreciate Secretary Johnson's continued support of our office and our joint work with USCIS to better serve those seeking immigration benefits. I appreciate your presence here today. Please join me in welcoming the Department of Homeland Security Secretary Jay Johnson.
Good afternoon, everybody. I came from behind a curtain. I feel like I'm a contestant on a TV show. It's great to see everybody. I like to tell stories to kind of warm up the crowd here. First of all, how's everybody doing? Good. Are you having an interesting conference? Yes. That was not a ringing endorsement. Are you having an interesting conference? Okay. All right. Thank you. Well, that's very meaningful for me for reasons I'm about to discuss. I have two kids in college. They are in college in Southern California, about 40 miles apart. And I'm under direction from my daughter, who's a freshman. Dad, whenever you come visit me on campus, can you dumb down the protection detail? Can you skinny it down? Leave blocks away the California Highway Patrol and all the extra Secret Service, and you have to really skinny it down. Don't embarrass me, Dad. You know, when you're a teenager, it's all about, don't embarrass me, Dad. Don't wear that hat. Don't embarrass me, Dad. So I'm under orders from my daughter. Whenever I go visit her on campus, I have to skin down the protection detail. And late September, I went to visit my daughter at her college. My son came over from his college 40 miles away to visit also, so they could both spend quality time with Dad. I followed orders. We had a smaller than usual detail on campus. But then I learned about this thing called Yik Yak. Who here has heard of Yik Yak? Okay, several of you. Yik Yak is this social media tool where college kids can chat anonymously back and forth on campus and talk to each other about, this class is canceled, or there's a party in this dorm tonight at 11 p.m. Everybody come. And so Yik Yak, when I stepped onto campus, even though I had the skinny down detail, Yik Yak lit up. College kids, we're all talking. Because the Secret Service, no matter how few there are conspicuous on a college campus. So the first entry from Yik Yak. What up? There are 2 Secret Service agents on campus. Next one. Obama is here. Next one. Obama's not here. He's in Delaware today. Calm down. Next one. Malia's here. She's looking at us for college. No, she's too young. She's too young to be looking at college. So then my son, he's getting the Yik Yak on his iPhone. And he can't help it. He's got to jump into the conversation. It's a Vin Diesel lookalike. But he has armed bodyguards. Why? Eventually somebody says, no, it's the fake Obama, the Secretary of Homeland Security. His daughter's a freshman here, dummies. Somebody finally said, wow, he has armed bodyguards. That means his daughter is not getting a date in 4 years. And I'm thinking, that was the intent. That was the idea. So let me begin by thanking all of you for the work that you do in individual case assistance. I have been Secretary of Homeland Security. I've been a senior official of the Department of Defense, the senior lawyer there, and I've been in the private practice of law now for over 30 years, one capacity or another. The most meaningful, significant moments in my public service career, my private sector legal career, were the individual cases where I actually could make a difference. They were the most memorable, and to me, they were the most significant. And a man who I admired much, I went to Morehouse College, a man who I admired much, the former president of Morehouse College, Benjamin Mays, said something that I like to repeat to people. He said it, Winston Churchill said it maybe, which is, you earn a living by what you get, you earn a life by what you give. And so one of the most meaningful experiences in my corporate litigator's private legal career were the pro bono cases. The case I handled for a gentleman from Pakistan who was seeking asylum in this country. The class action we brought in New York state courts on behalf of the mentally ill homeless in New York State. And the most meaningful moment in that litigation was literally tracking down the named plaintiff in the snow in the street to get his signature on an affidavit. It was the most memorable and most meaningful. In the Department of Defense, if you read my bio, I'm credited with helping to devise the legal architecture for our counterterrorism strategy in the Obama administration, and for contributing toward the repeal of the Don't Ask, Don't Tell law. But I will tell you that the most meaningful experiences for me in the Department of Defense were the instances where I could help somebody on an individual basis, the individual case assistants. The midshipman at the Naval Academy who was unable to graduate, who I helped make sure she could graduate. I'll never forget being at a ball game earlier this year. It was a Mets game. It was game 2. I got to throw out the first pitch. Yes, it went in the dirt. But I got to throw out the first pitch, and then afterward in the seats, a member of the Coast Guard came up to me and introduced me to her spouse and said, sir, because of you and your efforts, 2 years before, 3 years ago, I would not have been able to introduce you to my spouse. So thank you for everything. So it's the individual instances where we help people that make a tremendous difference in their lives and in our lives. That's what I believe. I'm responsible for an organization of 240,000 people, a $60 billion budget. We are responsible for counterterrorism, cybersecurity, border security, maritime security, aviation security, protection of critical infrastructure, protection of our national leaders, protection against chem bio threats, responses to natural disasters. And even there, the most meaningful moments for me in the job were the naturalization ceremonies and looking into the eyes of individuals who have just become citizens, or disaster relief, going to Arkansas, giving somebody a hug who lost their home in a tornado in a split second. But the most meaningful moments are the moments where we're able to help individuals. Prior to this job, I had not spent a lot of time on immigration law matters, on the enforcement and administration of our immigration laws and the immigration system. But I've learned a lot about the impact that our immigration laws have on the lives of individual people. Many of you may have heard about the multiple visits I made to South Texas this past summer in response to the situation there we had with the unaccompanied children. And the first such visit was, again, the most meaningful for me. It was May 11th, 2014, Sunday. It was Mother's Day. And my wife and I were out visiting the kids at college, my son at college. For Mother's Day, the idea was to go back to Washington, get to visit the other child who was then a senior in high school on Mother's Day, see both kids on both sides of the country on Mother's Day. In between, I said to her, I'd like to stop in McAllen, Texas, to see the kids and to see for myself what was happening, because it was just beginning, the situation there was just beginning to spike. And I wanted to see it for myself. So we stopped on the way back to the East Coast at McAllen, Texas. And we walked into this border station, this processing station in McAllen, Texas, which was flooding with children. When you walk into a processing center, you'll see a long desk with computer terminals, and you'll see a Border Patrol agent in green taking information from a migrant who has just crossed the border illegally, sitting on the other side of the table. It's essentially an interview. That day I walked in, there were the normal Border Patrol agents on one side of the desk, and on the other side of the desk were 7- and 8-year-olds, which was quite striking. And I went up to this little girl who had this beautiful long black hair, and I said to her, it was Mother's Day, I said, "Where's your mother?" And she said, "I don't have a mother. I'm looking for my father in the United States." And she started to cry. And the translator started to cry. And I started to cry when I had that encounter. And I came back to Washington that evening determined to do something about the situation. And the catalyst for that was the realization that there are individual human beings in our country who want a better life, who are at great hazard to themselves trying to get to this country, risking their lives on the train in Mexico. And I knew we had to address it. And so that personal encounter was one I'll never forget. I'll always wonder about what happened to that little girl. And so I recognize that the enforcement and administration of our immigration laws must have a humanitarian component to it, and it affects individuals, individual people, their families, each in unique ways. We are, as you heard the President say yesterday and numerous times before, developing a set of comprehensive immigration reforms that we believe we can issue within our existing legal authority to fix the broken immigration system, and we will do that in a number of respects. As the President said yesterday, it's always preferential to have legislative action to bring about reforms to a system that exists within the executive branch, but Congress has not acted, and we simply are not in a position to continue to wait. The system, in many respects, needs to be fixed, and we will do our best within existing legal authority to do that. And I suspect that when we issue our reforms, we will need the help of many people in this room to help us implement our reforms, to help people understand the reforms, to counsel people, to help them through a reformed, revised system. We will need your help. So it's significant that you're meeting here today. We will need your help in the short term. The last thing I'd like to say is, in my view, what you're doing reflects our values as Americans, for which I and a number of other people are very, very appreciative. One of the things I like to say in speeches, in Homeland Security, we have to find the right balance. We strike a balance between basic security and preserving American values. And so, on the one hand, the first impulse when we talk about Homeland Security, aviation security, border security, is build a higher fence, shut down this, screen that, prohibit this. But to take such an absolutist position would be at the cost of our values as Americans, as a free and open society. I like to tell people that I can build you a perfectly safe commercial air flight, risk-free, but no one will have carry-on luggage, no one will eat, no one will be allowed to leave their seat, and you'll be wearing very, very little clothing. Not be a very pleasant flight. I can build a taller wall. I can build a 15-foot wall, but somebody will probably then build a 16-foot ladder. But I can build a taller wall. I can build a wider wall. We can ask more questions. We can screen more people. We can subject people to more interrogation. We can make everybody suspicious of everybody in this country in the name of Homeland Security. But if we do so, we do so at the cost of who we are as a nation of people who cherish their freedom of movement, their freedom to associate, their privacy, their civil liberties, and cherish diversity and cherish our immigrant heritage. Those are things that we have to cling to, maintain. My job as Secretary of Homeland Security is to find the right balance, to strike the appropriate balance. I recognize that's part of what we do in Homeland Security, and I recognize that there's a humanitarian component to almost every aspect of what we do in the enforcement and administration of our immigration laws in particular. And so I want to thank you again for all of your hard work, your work with us. I want to pay a tribute to Maria and her office for the fine work that you do in relating to everyone else here. And you have some important work in the days ahead, given where we are right now. So thank you again to everybody. I very much appreciate it, and I hope you have a good conference here. Thank you. Thanks, everybody.
Thank you, Mr. Secretary. What an honor to have you here. And I am going to ask you to stay with us for a minute, and then we'll go through a few housekeeping matters and then break for lunch. exciting times ahead. So I will let Carly go through the housekeeping matters. I think I just made her anxious because she knows better than I do. Thanks again. I look forward to seeing you after lunch during our panels. I think there's still a lot of good dialogue ahead of us, and I look forward to seeing you later.
Great, thank you. As Maria stated, I would like just to echo thank you for your participation this morning. And I'm going to keep you here while the secretary exits and go over a few announcements. The afternoon panels that are on your agenda that are not located in this room are located on the upper level. So if you plan to attend the panels in the Washington room and the Jefferson room, when you return from lunch, you can use the elevators or the stairs that are located on the east side of the building. For those of you who are like me, that's the right side of the building as you come in. If you need additional note cards for questions during your afternoon panels, you can ask the moderators in your afternoon panels, as well as any member of our staff. Our staff members all have name tags with the ribbon below to let you know that we are part of the staff. You will see in your folders that we've included surveys. These are very helpful in us in planning and giving feedback to our presenters. So we ask that you please take some time to fill those out. You can turn your surveys into our staff after your afternoon sessions, or you can use the boxes located at our registration table. If you would like more information about our office or the Blue Campaign while you're here today, we have some information tables located outside of the corridor that leads to this auditorium. We have some staff there. They'd love for you to come by and talk to them, and they have some materials for you as well. You may notice on the agenda that we had allotted a 15-minute interval between your return from lunch and the start of the afternoon panels. This is because entrance back into the archives building and then getting to your panel location does take a considerable amount of time. In our experience, a 15-minute allotment is a fair estimate of how much time it's going to take you. So please keep that in mind as you head out for lunch. Your folder has information about restaurants in the area that you can visit. There is an alternative to leaving the building as well. There is a cafe located on this level to the left as you exit the corridor for the auditorium. They have prepared several boxed lunches for this conference. They also have hot items there and items that they can prepare to order. They have told me they have a veggie option in the boxed lunches as well. So at this time, I'd just like to say, please keep in mind the time that you are coming back to make sure that you're here in time for the afternoon panels, and we look forward to seeing you then. Thank you.